starting with the state.
Now, good morning, ladies and gentlemen. Good morning. I started this trial by saying thank you. I want to end it in the same way. You all have been paying attention. You have been taking notes. You have listened to the testimony presented by the witnesses. You have viewed the evidence as we've seen it on these screens, no matter how long it might take to get up there. So we appreciate it. But you have paid attention and prepared yourselves for the hardest job. And I told you that. It's to decide the truth of what happened on the night of February 25th, 2022. Because that shot that we heard, that single shot to the head of Thomas Allen Arnold, that single shot directly to his face was the definition of dome cat. See, we're here because the defendants told you exactly what they did, but it's still our job to prove beyond a reasonable doubt, to corroborate that evidence. But we start from those words and work our way to a guilty verdict. Now, I have a chance to talk to you first because the state carries the burden. We're the only one that carry a burden. Then you'll hear from the defense. And then I'll come back to talk to you about the evidence. Go back through exactly all of the breadcrumbs they left that led to the guilty verdict of Brandon Delshawn Williams and Demetrice Ross. But this morning, I want to talk to you about the law. The judge is going to instruct you on the law at the end, once we have all sat down. But I want to take some time to go through some of those concepts. So your duty, that's where we started. Your duty is to follow the law. That is being a fair and impartial juror, honestly seeking the truth. You heard that time and time again during the jury selection process. It's important to remember that you are not to seek doubt, but to seek the truth of what happened that night. You also heard during the voir dire process that you are bound by the law that the judge is going to instruct you on. Not what you may have heard on TV or seen on forensic files one time. It is what applies to this case. It has been reviewed by the parties. It is what is appropriate in this case. You are bound to follow that law. And your duty is to deliberate. That's the most important duty. So if you get back there and someone refuses to do so, please send a note to the judge, because everyone has to do their job, no matter how difficult it may be. Now, the way I like to talk about your duty, your role when you get back there and begin to deliberate on this case, I like to think of it with this visual. See, what we ask, what is required, is that you leave outside of that circle all of those items. Any passion, any public opinion, unhappiness with the police or anyone else, public feeling, sentiments one way or the other, sympathy for the defendants, disagreement with the law, you're bound to follow it, conjecture or unbased opinions, penalty and punishment that is not for you to decide, and then any prejudice that exists on any matter one way or the other, leave that outside of that door. What you take back there is what's in the middle of the circle. The law that applies to this case. You'll get a copy of it, but take notes if you have any questions. The testimony of the experts. When you heard from Detective Sluss about how that cell phone location, cell site data corroborated the words that we got from Mr. Williams. We were there that night. Yeah, that's me in the photo. That's taken right there on the belt line. That's also captured on the surveillance footage. The testimony of the lay witnesses. You heard from Mr. Crawford. You also heard from everything that Mr. Crawford went through before he got here. You heard from Detective Parent. She didn't even put his name and information in the report because he had reported threats. He told you about the threats he got even after this happened. And he still came here and told you exactly the same thing. Physical and digital evidence. You have seen us walk through a lot of video. And there's tons more. But you've seen what's pertinent. You've seen that and heard that out of the hours, the days that were reviewed by the police, by the DA's office, the technological evidence that was reviewed by the police, by the DA's office, they came to the same conclusion, which is the guilt of Brandon Williams and Demetrice Ross. Positive identifications. Other than Mr. Williams pointing it out for us, Mr. Crawford said, I know all three. That's Brandon, that's me, or Demetrice Ross, and that's Taboo. Then we had the photos in the phone. Then we had the text messages sent. Then we had Miss Rivers coming in and saying, yep, that was him. Miss Reese, who only saw him on that one time where she snapped a photo, just to confirm he was at that house on March 5th and something didn't feel right. But she knew who it was. Elements of the crime we're going to talk about this morning. But the most important tool you have back there is your common sense. That's it. Logically, how many coincidences does it take? Because it can't just be a series of coincidence upon coincidence upon coincidence. It's evidence. But your common sense is the greatest tool you have. Now, the burden of proof, again, the state is the only one that carries a burden of any sort. We carry the burden of proof here, which is to prove the case to you beyond a reasonable doubt. Now, I want to be very clear in that distinction because it is not proof beyond all doubt. It's not. That's an impossible burden. It's not proof to some mathematical certainty. I can't give you a percentage. And it's not a vague or arbitrary doubt. Is there a secret passage that somebody tunneled in 1922 under Beach Circle where somebody popped up, pushed all three of them out of the way, and then they did it? Is that reasonable? That's the difference. Not beyond all doubt. Not is it possible, but is it reasonable? It is the doubt of a fair-minded and impartial juror, honestly seeking not doubt, but the truth. That's the difference. Now, the way I like to think about it, y'all see a lot of photos in here. I like using them for examples. But I love puzzles. I don't get to do it that much these days because I'm in here. But if I get a second, I like to use puzzles. And you get a box. There's a picture on the front of that box that shows you what it's supposed to look like. And you open up that lid and you see pieces scattered everywhere. Now you start, if you're good, with the corners, trying to put it together. Then you fill in a little bit more from there. And the picture starts coming together. That's how you know you're on the right track. Then it comes together more. That's how you know where you are. Now, if you pick up a puzzle, maybe sometimes at the Goodwill, you might miss a piece or two. It happens. I can't tell you looking at this puzzle on the screen what this is beyond all doubt, because there are a couple pieces missing. But I can look and I can see $1 at the bottom. I can see the name Washington right above that, and I can see a picture of a man who looks a whole lot like George to me. So I can tell you beyond a reasonable doubt that that is a puzzle of a $1 bill. That is the difference. That is the burden that we are held to. You might have some missing pieces because you can't do beyond all doubt, but is it reasonable? Is the conclusion reasonable with the pieces and the evidence that you have? Now, presumption of innocence. Both defendants walked into this courtroom with a presumption of innocence. It's good to think about it like a coat. They had that coat on their shoulders. They were cloaked in innocence. However, as the evidence came out during the course of this trial, as you viewed those videos, as you heard their words, as you read their words in the text messages, as you saw the phone evidence, as you heard from witnesses, that evidence acted like a thermostat in the room, and it cranked up the heat. And once it got to a certain temp, those coats came right off. That's how the presumption of innocence works. You walk in with it until it is overcome by the evidence that proves their guilt beyond a reasonable doubt. And I submit to you, ladies and gentlemen, that we have reached that point. Now, that evidence can come in two different forms, direct or circumstantial. You're going to hear about that in the law that's read by the judge. What weight is deemed important or necessary in your conclusion on either or is entirely up to you. Whether it's all circumstantial, whether it's all direct, whether it's a mix of two, it is your decision. Now, direct evidence is something tangible. It can be seen on the Beltline video, on the numerous videos where we see tracking this group, but more importantly, all the groups. There wasn't a single person pointed out and we weren't able to pull up and say where they went, except for Tabu, Brandon Williams, and Demetrice Ross. Something that can be heard, like that fatal gunshot, but at 10:27 p.m. Right in line with when we see Mr. Arnold take his last steps onto that path headed away from any further camera view. The documents that you have here, the conviction for Mr. Williams, the text messages from Mr. Ross's phone, the call log that shows right up until that point of arrest on March 16th, he was in contact with David. That is direct evidence. But you also have circumstantial evidence, a little bit different. See, circumstantial evidence is proof of facts or circumstances using direct evidence, but to infer reasonable connected facts. I like a picture, I already told y'all. So let me explain how I think of circumstantial evidence. Now, maybe you do this often. I definitely had to do it this morning. But on my way here, I look, I get in my car, and I see a little orange light. Looks like a gas pump. And I say, well, looks like we need to stop. So on my way in, I pull over, I go in that gas station, I pull up next to a pump, I get out, turn my car off, put my card in, select which grade, put it into where my gas tank is. I hold that lever until I feel a click. And I watch the numbers going up. Because I was on E, it kept going up and up and up. But once I feel that click, I then release. I put it back in the pump. I get my receipt and I turn on my car and drive off. Now, during this process, I didn't actually see gas going into the tank. I didn't tangibly have anything to tell me that gas ended up in my tank. But I can use circumstantial evidence. The fact that those numbers kept going up, the fact that I felt the click, the fact that when I got back in my car, that orange light was gone and I was able to make it to the courthouse. Circumstantial evidence that works to tell me beyond a reasonable doubt that I now have gas in my car. That's the difference between the two. The time frame that we have created here. You are able to see the trajectory through those videos. You're able to see them at that corner of Bernina and Elizabeth, walking up Elizabeth, going right past Pier Taqueria down North Highland, going back around Bernina, then going on to the Beltline, being under the bridge, walking away from the bridge right after that woman, and after we see the woman come on, back onto Elizabeth Street, we don't see them. But that created a time frame through circumstantial evidence. The same with the gunshot. We hear it at 10:27 p.m. We saw Mr. Arnold walk by the camera at 10:25. Circumstantial evidence. The witnesses, their testimony, their credibility as you deem it, the exhibits in all form or fashion are evidence. The testimony of a single witness, if believed, is enough to establish a fact. There is no corroboration that is required by law. We'll not hear that. But here we have it. We have it. But it's not even required. If you believe the words that actually came out of Mr. Williams' mouth, but then that Mr. Crawford repeatedly relayed to police, to fugitives, to you, if you believe that testimony, it is enough to establish it as a fact. And the credibility of each single witness is up to you, how you determine it. And in doing so, you can use any of these factors: the manner in which they testify, their interest or lack of interest in the outcome of the case, the means and opportunity they had of knowing the facts they testified to. You don't have to wonder whether or not Mr. Crawford had access to Mr. Williams, because we see a video that was taken live of Mr. Williams saying the things he had already reported to police. He's even present on the body cam footage of Mr. Williams' arrest at the hotel. Does he have the means and opportunity for knowing the facts to which he testified to? The nature of the facts, the probability or improbability of something happening, what they testified to, and for each witness, their personal credibility as you observe it. Those are all factors you can use in determining the credibility of each single witness. Now, you're going to hear law about the party to a crime doctrine in Georgia. Now, in this state, a person is party to a crime if they either directly commit the crime or if they intentionally help in the commission of the crime. If they provide the gun that they got from the pawn shop that can't be traced anywhere and hand it over for you to shoot the final shot, crime. You are guilty of that same crime because but for your actions, we could not have made it to that. Wouldn't be a morning here without some technological difficulties, but we'll keep pushing on. Now, if you participate as a group and in concert, as we see them moving throughout the area, as we see them moving back, and as we see them leave off of that camera angle together, and as we see with the phone location data, them moving together. That proves the party to the crime doctrine. But for Mr. Ross providing that gun, there is no fatal shot. But for Mr. Williams pulling the trigger like he claimed to, there is no fatal shot. We watch Ross, Williams, and Taboo move as a group at every turn. They went in as one group. They acted as one group. They ran and hid as one group. And they face this as one group, but you know that the final factor isn't present here today because he can't be. You've heard the testimony about Amir Rosario being Taboo and that Amir Rosario is no longer living. If he were, he'd be right at that table. You'll also hear about conspiracy. That is when one or more persons conspire to commit a crime. And if any person in that group that conspired does an overt act towards the commission, they are guilty of being a part of that conspiracy. Now, how do you determine if they had an active part? Presence, companionship, and conduct before and after the commission of the crime. Presence, you saw that on the video. Companionship. Other than seeing it on the video, we saw it through the phone communications. Sharing numbers, the calls that went back and forth, the text messages. Conduct before and after. Talking to each other about it. Another cold case. Yes, sir. Pay attention through the evidence to the actions of all before, during, and after. And that's how you get to the party to a crime, the conspiracy that was committed that night that led to the death of Thomas Allen Arnold. Now, intent. Intent is a necessary element to every single crime, but it can be in two ways. It can be proven by facts and circumstances or by acts and conduct, or it can be inferred. Inferred is when it is the natural and necessary consequence of the actions. The natural and necessary consequence of pointing a gun at somebody and firing a single shot to their face is death. That is why this is a homicide. That is why the charge is murder. You may find intent for any of the actions, the charges in the indictment by the acts, the conduct, the demeanor, the motive, any of the circumstances connected to those facts. That is how you can find intent. And consider the conduct of this group. Before. Intent being shown when they're going through the black BMW, traveling the area together. During. It's 3 and it's 1. A mere couple minutes after we see Mr. Arnold pass by that corner, we hear that gunshot. He didn't stand a chance. He still had his right hand in his pocket. Ross provides the gun. William fires it. Single shot. And as Mr. Williams said, they didn't even go in his pockets. You saw his cards, a little bit of cash he had. Only thing we didn't see is car keys or house keys. And then after they leave the scene, you can look at the times related to what Detective Slush was able to pull from the phone records with the cell site location. They're communicating with each other. The call log we have from Mr. Ross's phone, the number of calls just purely on the 26th and 27th, and the last call on March the 16th, the same date he was arrested, to Taboo. Researching the case, having that same Channel 2 media release that you all got to see a snippet of. It made its rounds, whether it was from Mr. Williams or in Mr. Ross's phone. And then the plan to hide out, you saw that in the text messages, the final text messages we had between Mr. Williams and Mr. Ross. Their movements after, during, and before all point to the intent necessary, essential for every single crime in this indictment. It doesn't have to be an intent to go out and commit a crime that day. Though apparently that was the plan. But legally, it doesn't have to be intent to commit a crime. It has to be intent to do the actions that constitute it. The intent to raise your hand up, pull a trigger. The intent to pass over the gun. The intent to see that man walking, go up to him and make sure that he is dome capped and left to be found the next morning by people just jogging by. That's the intent. Now the charges. There are a total of 9 charges in this indictment. You'll get a copy of the indictment back there with you as well. 1 count of murder, 3 counts of felony murder, 1 count of criminal attempt to commit armed robbery, aggravated assault with a deadly weapon, possession of a firearm during the commission of a felony, possession of a firearm by a convicted felon, and then hindering apprehension of a criminal. So I want to walk through these just so we can talk through the elements of each. Beginning with murder. So count 1 of murder is when a person commits murder because they unlawfully and with what's called malice aforethought cause the death of another human being. We know here that it's Thomas Allen Arnold. Malice aforethought is not ill will or hatred. You don't have to have some type of connection to the person. It is the unlawful intention to kill, to fire a deadly shot to someone's face without justification, excuse, or mitigation. You've heard none of that. It can either be a deliberate intention to kill. We know we're coming out here. We know we're going to make sure we catch 1 body or 2, according to Mr. Williams. Or it can be implied. When you show a complete disregard for human life. You saw the horrific photos of Mr. Arnold when he was in Beach Circle and then when he was on that autopsy table. Firing that shot into his face is the definition of a complete disregard for human life. I don't have to explain that part. Premeditation. I know this is a concept that we hear a lot in media and news and in public and on TV, all of that. Meditation is not required, despite popular belief. It is not a required element of murder. And even if you find that it was related to this crime, it is not necessary. There is no particular length of time for malice to be generated. Malice of forethought can be generated in the second it takes to fire a shot. That's how quickly malice can be formed. That is not premeditation, because premeditation is not required. Motive. Also not required by law. Proof of motive is not required to prove that a homicide, a murder occurred. Now, evidence of murder, of motive has been admitted just so you have some insight as to the defendant's state of mind. There was no justification, no mitigation, and no excuse for the actions. But if you disagree on what the motive is, even though Mr. Williams said it was to steal a car, take it to the chop shop, if you disagree with what the motive was for the killing, it is not a required element for finding guilty or not guilty for that charge. All that is required is that you prove that it was an unlawful killing. And again, that means no justification, mitigation, or excuse. Now, counts 2, 3, and 4 are slightly different. This is felony murder. There is no malice aforethought required for the charge of felony murder. This is when a person commits a crime that is designated as a felony, and that causes the death of another person. So if I came out there and I intended to commit an armed robbery and I attempted to do so, if you had that intent and you are guilty of that felony, then you are guilty of felony murder because that caused the death of Mr. Arnold. If you plan to take a gun, point it, fire it, because you pulled the trigger, you are guilty of aggravated assault with a deadly weapon. We'll talk about that charge, but that caused the death of Mr. Arnold. So then you are guilty of felony murder. If you are a convicted felon due to a Clayton County charge in 2019, and you possess a firearm against the laws of the state of Georgia, your possession of that firearm is what caused the fatal shot and death of Mr. Arnold. You are guilty of felony murder. That is the difference between those charges. You do not have to intend to cause a death, just the act that led to it. Aggravated assault, criminal attempt to commit armed robbery, and possession of a firearm by a convicted felon as pertaining to Mr. Williams only. Those are all felonies. Criminal attempt to commit armed robbery. This is when a person performs any act that constitutes a substantial step towards the commission of armed robbery. That's the criminal intent part. Armed robbery itself is when somebody intends to commit a theft, taking some type of property from the person of another, this being Mr. Arnold, from his immediate presence with the use of an offensive weapon that is a firearm. If you intended to commit this armed robbery, even though it wasn't completed, even though you may not have gotten anything, it is still criminal attempt because you took that substantial step. And we have the results of it, unfortunately, which is the death of Mr. Arnold. Aggravated assault with a deadly weapon. Talked about that a little bit, but this is when someone attempts to commit a violent injury upon another. That's an assault with the use of a deadly weapon. A firearm is a deadly weapon as a matter of law. You don't have to guess about that. Shooting Mr. Arnold with a handgun, both actually pulling the trigger or as party to the crime, makes you guilty of an aggravated assault with a deadly weapon by law. Count 7, which is possession of a firearm during the commission of a felony. A little more straightforward than the others, but when you have on or within arm's reach of yourself a firearm, deadly weapon as a matter of law, during the commission of a crime, that is possession of a firearm during the commission of a felony. Murder, felony murder in all the forms listed, aggravated assault, and criminal attempt to commit criminal attempt to commit armed robbery. They are all felonies. You only have to find they were guilty of one for them to be guilty of possession of a firearm during the commission of a felony, if you find that all the other elements exist. And count 8, this is possession of a firearm by a convicted felon. Again, this is as to Mr. Brandon Williams only. If you find that he is guilty of a felony, has been convicted of a felony previously before the date of this incident, and possessed a firearm, then you would find him guilty of possession of a firearm by a convicted felon. Now, particularly looking at possession, there are two ways that possession can manifest. It is either actual or constructive, and you'll hear the law on that. Actual possession means that at the time of the offense, you held and had direct physical control over the firearm. That's actual possession. But you also have constructive. Constructive possession means that you didn't have direct physical contact or control over the firearm at the time of the crime, but you did knowingly have the ability and the intention to exercise it. Did you bring it? Did you hand it to the person and they fired the shot? Did you watch them do it as you stood by? That is the difference between actual possession, but also constructive. Now, the last count of the indictment pertains only to Mr. Ross, and that is hindering apprehension of a criminal. That is when someone with intention to hinder the apprehension or punishment of a person who they have reasonable grounds to believe has committed a felony, murder, felony murder, criminal attempt to commit armed robbery, aggravated assault, possession of a firearm by a convicted felon, name it. If they harbor or conceal that person, you would find them guilty of hindering the apprehension of a criminal. So when Mr. Williams sends the plan, found us a remote spot, it's about 10 minutes from E, really in the middle of nowhere. Leave your car out there, we'll meet up, and you say, I bet, it's a go, and you go about your way, and then go hide out in Morrow until the police find you, that's hindering the apprehension of a criminal. Now, pay attention as you go through the evidence, as you listen to the closing arguments from Mr. Norman and Ms. Hemingway on behalf of their clients. But what we saw after, we went through before, we'll talk about during, but after, we talked a lot about this morning. If the actions of the defendants go towards some type of acts of concealment or attempts to influence, then that can be considered evidence of what's called consciousness of guilt. Pay attention to what happened, not just on the 25th of February, but on the 5th of March, on the 10th of March, on the 11th of March, on the 12th of March, all the way out until the 16th of March? Does it provide evidence? Do those actions speak towards a consciousness of guilt? Again, the judge is going to instruct you and provide all of this law that applies to this case. And I'll come back and talk to you about the evidence at the conclusion of the defense's closing statements, excuse me. But I submit to you that we are past that cloak of innocence. We have met our burden and proved beyond a reasonable doubt the guilt of Mr. Williams and Mr. Ross. Thank you.
On the Department of Labor case, ma'am, is the other party here? Yes,
Ask about for a moment.
you may. Are you Mr.
Mr. Marcus.
All right, well, Mr. Mock, you didn't appear at both of your appeals. I don't know how you have any ability to be before this court. You on 7/9/24 they called you. You didn't answer, didn't appear.
You want to share your?
Oh, I gotta reshare it.
Back here.
All right, Missouri. All right, the President.
Please be seated. Please begin with the first defense closing argument.
Let me know if they get in anybody's way. There's no podium here anymore, so it's the closest thing there. Thank you guys for your attention. In this case, I represent Brandon Williams along with Charlotte Carter, as I mentioned in opening. Again, as I said in opening, you were gonna hear a lot more from the state because of their burden, and that was in fact the case. I made an opening statement, and I want to tell you, as I stand here now, that I stand by that opening statement. I told you several things. One of them is that you were not gonna see the person who killed Mr. Arnold in this courtroom. We believe that person is Amir Rosario. I told you that I also told you that there were going to be an investigation based on unreliable witnesses. Well, I backtrack a little on that. Unreliable witness, Shaquan Crawford, who you met. I told you it was a rushed investigation. And again, I'm going to change my words there a little. Maybe a better word is sloppy or lazy investigation and not rush. And so I told you the state would be unable to meet their burden. And I also believe that still to be true. And the final thing I asked you to do is to judge Brandon Williams on this case and the evidence that has been presented in these four walls over the last few days and not his past. And you will get a limiting instruction when the judge is reading the instructions to you that says just that. You can only think about his past as it relates to two charges in the indictment. And the judge will give you instructions on those. Judge him on what you heard here and the witnesses that you heard from here and the evidence or lack of evidence you heard during this trial. Again, our technology is sometimes will touch you. All right. Now, Detective Parent told you that she did a thorough investigation. I think we're at your stop. Okay. Detective Parent told you that she did a thorough investigation in this case. But we know several things. She didn't collect evidence at the crime scene. The water bottle, which could have contained evidence that would have been relevant. We know that she didn't search Brandon's house. Now, I'm not a police officer, but it seems if you're accusing someone of murder, you arrest them, one of the things you want to do is look for evidence related to that murder. And you go to their home, places you know they've been. Now, she said to you, I couldn't search his house or where he's been because he moves around too much. Well, you know what could help with that? She had Brandon's. I believe she forgot she had them. You heard the testimony here. But the last person who testified showed you all that fancy location data. They had that information. She knew where Brandon had been, and so she would have known he had been at his home and he had been at the La Quinta Inn. And searching two places doesn't seem like too much effort to put into a murder investigation. Again, she told you she did a thorough investigation, didn't bother to search the suspect's home. She also told you, I did everything I could to try to locate the owner of this black BMW. But you saw that car get a parking ticket. We know the exact time that that ticket was written. We know what company wrote that parking ticket. And what information is on the parking ticket? License plate number at least. And if you've ever gotten a parking ticket, usually the name of the owner and their information. So in her thorough investigation, when she says she's looking for this person who's so important to her investigation, she didn't even bother to do the minimum. Kind of delayed. All right. Now, as soon as that box goes away, a police officer's job is to gather proof of a crime. Again, an officer's job investigating something, especially something as serious as a murder case, their job is to obtain proof. Now, again, you saw Sergeant Parent get on the stand. She had a lot of assumptions. Again, going back to that black car. What did she say when the lady went back to her car? Oh, she must see signs of a break-in, and that's why she's hovering around the front of her car. That wasn't true. That was an assumption. We know the lady got a ticket. She stopped to get the ticket off the front of her car. She says, oh, they're out breaking into cars. Well, let me show you. If you can look at the bottom video here, which will start playing in a second, there seems to be a delay, but you will see on that street where you see Brandon walk up that street. It's full of cars. Brandon walks on the other side of the street, doesn't bother to look in a window of a car, doesn't touch a car, but they're out breaking into cars that night. That's their whole purpose, according to Detective Parent. Where did she get that from? She got it from Shaquan Crawford. And here, I think the video started, you can see. Brandon, as we can see in the green pants, is over there. Now, she also told you that when I asked her, they walked past a full parking lot of cars at an apartment complex. Said, oh, they couldn't get in there because there's a gate. They're out to steal cars, but I want you to look at the gap at the bottom of this gate. And if you think somebody's out to break into cars and you're trying to get into this parking lot and it's just too hard, because they could roll under that gate if that was their purpose, but it's not. It's another assumption by an officer that's supposed to be looking for proof. Apologize, our technology is Well, I'm waiting for the next slide to pop up. Detective Parent's investigation was simply Shaquan Crawford. She didn't look for the owner of that car. She didn't try to find evidence of a murder at Brandon's home. She just relied on what she was told by Shaquan Crawford. All right. Now, they tried to tell you that Malik Williams was proof of how good of an investigation they did, right? Like, we only had him in prison for 4 months before we figured out that he wasn't the guy. But that doesn't track. It's actually proof, more proof of the lazy, sloppy investigation that was done. You heard testimony from the last witness, or second to last witness, that Detective Parent had everyone's phone records. She had Amir's phone number. Amir is also is taboo. She had his phone number. She had Brandon's phone number. She had Mr. Ross's phone number. They had all this information. They had location data. That did not stop her. Even though she knew the number didn't match for Malik Williams, she still arrested him. And she arrested him immediately after Shaquan Crawford told her that that's the guy. Again, Shaquan Crawford was her investigation. That was it. And how do we know that? Again, he identifies Malik Williams, who turns out wasn't even in Atlanta, at 6:13. At 8 o'clock, 8:04 to be exact, she goes and gets a warrant for his arrest. And you've seen what that means. They send the fugitive squad out to pick people up. They don't call you and say, hey, you want to come in? When they sign that document, men with guns come and get you out of your house. Now, you as a jury get to judge the credibility of every witness that testified in this case. And if you recall during jury selection, I repeatedly asked if you will treat a police officer the same way you will treat a lay witness, and that is the law. So police are to be treated like every other witness that testified in here. And I want you to remember Officer Parent's demeanor when I was asking her very simple questions. She wouldn't answer simple questions directly. That's something for you to take into account. She took every opportunity to say, clients are up to no good. Look, in my experience, looks like they're breaking into cars, right? They got in one car, one unlocked car, who she doesn't know they didn't have permission to get in. Think about all the assumptions she made when she was testifying. She even told you when she was on the stand that she couldn't identify Brandon Williams when he was being arrested based on the warrant that she had obtained. You remember this video? Says, I don't know if we got a phone.
315. Let me hear your voice.
Man, get my phone, man. Get my phone now.
I don't think you're gonna be needing that for a
Man,
while.
I don't, man, what you talking about?
Cut this off. Hold on, just careful. Be careful, right? No, you just
Y'all don't know why you take the damn book off.
Watch out, see. Yep.
Man, what y'all in the room for?
Yeah, just clear.
Hey, let me get that phone. Let me get that phone. Put that phone in my pocket.
Spread your face.
She told you, she looked at that screen, we were all in here, and said, I'm not sure that's Brandon. I can't be sure. Think about that when you're considering the credibility of witnesses in this trial and their demeanor.
Done that book that was before.
Now, as I said before, Detective Parent, her investigation was Shaquan Crawford. And in this case, you can't trust him. Again, consider his demeanor in this courtroom, consider the lies he told while he was on the stand. Now, I'm not gonna remember them all, but I put down the one I remember this morning. Just in the time he was on the stand, he told you he had never met Amir or Taboo. He said Taboo, we now know Taboo is Amir. So, he said he never met Amir. But then you heard throughout the trial from other witnesses that said, oh, he met him several times. He wasn't as close to him as he was to the others, but he knew who he was. He got up here and said he's never seen him. He told you, if you remember, when he was asked, could you ID anyone in September? No, I just said he kind of looked like him. I wasn't sure. I didn't ID anyone. And then I showed him the document, Defense Exhibit 1, where he signed and said, I ID'd someone. That's another lie. He said Amir was threatening him in September of 2020. Amir was dead in May. We know that now, right? Another lie. Said he never called Brandon's mom. Told him if he testified, they would go free. Until I played it for him. Now, because of rules of evidence, you didn't get to hear that call. But you all were here when I played that call for him, and then he admitted, oh, I did call it. That's another lie. Said they were out on the walking path to steal cars and take them to a chop shop. Well, you've seen the videos. They walked by cars on Renina Street. They got into one unlocked car. They never talked to the owner again. Could have talked to her. They had a ticket. They have information. Didn't bother. They walked past all the cars on Elizabeth Street, back around, past a parking lot full of cars. Didn't touch a single one. But that's their motive for being out there that night. Now, Juan Crawford said Amir was unpredictable. And that's consistent with what happened that night. Now, why would Shaquan lie? I don't know. I can't tell you. Shaquan wanted to be involved in this case for some reason. Could be the $35,000 reward. Could be he was protecting Amir. Could be he was scared of Amir. I don't know, but I don't have to prove that. All I can tell you is you all saw him lie, and he is the basis of this investigation. Because parent didn't do anything except obtain video footage, which y'all didn't watch all of, or should have known the lady got a ticket. Now, let's talk about the video, which I'm going to play for you in a moment. I couldn't get it into my PowerPoint presentation, so I'm going to talk about it and I'm going to play it for you. The context of the video is left up to Shaquan. It's 51 seconds long. Shaquan chooses when to start the video. He chooses when to stop the video. And he chooses the context in which to put it. Now, there's obviously multiple people out there, multiple conversations. They're listening to music. Hard to hear, but I want to tell you things that I find that are important. And I've listened to this more times than I would like to admit. Brandon Williams says, referring to the he dome captain. He referring to Amir. He then says something about catching two in the same night that are never found. We know that that is not related to this because there's only one incident. Brandon knows that person has been found because that's why he's even talking to Shaquan. But then the next statement is what's really important and puts it into context. Because the next question is, well, where is he? Again, because we're talking about Amir. And they say Amir, well, say he is up, he's gone to Texas. That's how we know that's what that conversation is about. Multiple people talking. Now, Shaquan could have recorded longer, could have recorded the beginning of the conversation. He chose only to record that part. Detective Barron chose not to ask for any more information. This is what we have. I'm gonna show it to you and you can make your own determination, and this will go back with you. I'm done. Here, moving stuff. And again, I apologize for the technology issue, but here we go. Check space.
Baby, you look like a boy. Okay. What you mean? Y'all didn't get no. What you mean? Y'all didn't get no money out of me? I ain't got no money, man. That nigga didn't go in his pocket, man. I said, man, God damn, man, that shit make me. I don't even want to think about that shit. What happened? He busted pocket. Don't shot that nigga up. Don't shot him. I caught 2 on him same night. They still ain't found him. Shit. That's crazy. So what the hell goddamn what's called it? Taboo up, man. That nigga finna go to Texas. Where he at? I can dig it, bro. He up? That nigga up, man. That's what I'm saying. Me and me, we grinding.
But you got other niggas with you?
Shit, yeah.
Again, says I don't even want to talk about it. He don't capture. Then at the end again says, where is he? He's gone to Texas. Other witnesses the state put up. Edna Rivers. Known Brandon 8 years, never seen him with a gun. Doesn't know anything about the crime. Did know Brandon was just waiting for his mother to return from out of town so she could tell him what to do. Miss Reese. Doesn't know Brandon, doesn't know anything about this case. Just knows she didn't want Brandon home when her son got home. Detective Sprinkle, again, one of Shaquan's lies. Detective Sprinkle testified that Shaquan told him he had met Taboo Amir on multiple occasions. And the phone guy, Slosh. His testimony was they were near the Beltline. Well, we know that, right? He can't say they were together. He can't say they were at Beach Circle together. He can say that they were in the area of the Beltline when we saw them on camera. So that is their testimony. Now, we know that there was no robbery or attempted robbery because Arnold's $7,000 watch still on his wrist. Nobody tried to get it off. The clasp isn't open. Wallet, all the contents are still in it. Said the testimony was there was no sign of a struggle. There was no robbery. They brought up today keys. There was no testimony. He even took his keys with him. He walked. So if he doesn't have his car keys, that's not unusual. All kinds of ways to get into your home now. You got apps. I can enter my house with my phone. Just depends. Again, we don't have to prove what happened. What we can tell you is there was no robbery, no attempted robbery proven in any way by the state. Again, just as you can see, like we talked about, or like I talked about, in the street to the infamous BMW, they walk past a whole street of cars that are further down in the dark. They get into the unlocked car that happens to be at the only busy intersection back there. That doesn't indicate to me that they were breaking into it. And I told you again, killer would not be in this courtroom. And I knew that because Amir Rosario was killed in an attempted robbery in May of 2022 in Decatur. You heard Detective Schuler come in and testify about that. And during that, when he was killed, he managed to get off a shot, 9mm handgun, was all alone, by himself. And you can look at his behavior when they were on the Beltline. When you watch the videos related to this case that were presented, you will see that Amir is often out front. He's moving around. He's acting different than Brandon is. Maybe you'd say he looks like he's on the hunt. I don't know. But Amir Rosario is out. They're trying to make them a they, but it's a him. Who pulls on the door? She said they pulled on the door. Amir pulled on the door to the apartment. You saw that video. Nobody else. And let's look at it. Here they are, walking up Elizabeth Street again. And I know I showed you this a moment ago, but at this point, I want you to pay attention again to Amir's behavior. Amir is always slightly separated from the other two. When you see him on what they call the big camera, you'll see that he's out front. When they're walking here, Amir is on the other side of the street. When they're checking on the doors, that's Amir. When they come around the apartment, you see again, Amir is out front. And again, you get to see all of these things. Another, again, Amir up front, head down, hood on. Kind of dark clothing. Brandon, bright green pants. Not what you wear to go out when you're gonna have a night of crime. Now, I want to talk about the medical examiner's testimony. Arnold's 5'11". You've seen Brandon as you've coming in and out this courtroom for the last few days. And you know how he's much shorter than that. The trajectory of the bullet, backwards, downwards, and to the left. That means, and you heard the testimony, that it entered the front and went downward. At a downward angle. Now, medical examiner said she couldn't testify necessarily to the height of the person because she doesn't know the position of Mr. Arnold's face at the time. What we do know is he had an injury that she said was from falling from a standing position. He was upright. The other thing we know is that this is not the Kennedy assassination. There are no magic bullets. Bullets travel in a straight line. Brandon, who's much shorter than Mr. Arnold, would have had to fire like this. Amir, who you see in the videos, much taller. Just consistent with what I told you. Now, the state made a big deal about the text messages. And as I told you in my opening, Brandon was scared. He was watching the news, saw himself on there as a suspect for a murder. I've never been on the news as a murder suspect, but I can imagine that if I saw myself on the news, I would get scared. I might even text someone and say, hey, I'm on the news. What should I do? And that's exactly what Brandon was doing. He was waiting for his mom to come back. He was reaching out to everybody he knew, saying, hey, I just need to figure out what to do. That's not evidence of anything, except that he was scared. He was on the news as a murder suspect. The texts also don't start until the news reports come out. It's not like on February 26th, they're texting saying, hey, we screwed up last night. Let's figure out a plan. There's no text messages before February 25th where they're saying, let's get together and go steal cars or whatever they're claiming that the motive is. It's when they saw themselves on the news, they got scared, wanted to figure it out. Brandon, you heard testimony, was just waiting on his mom to get back in town so he could figure out what to do. Now, I want to talk about the charges themselves and why the state cannot meet its burden as it relates to Mr. Williams. And the judge will instruct you on the law as it relates to it, but I put it here for you as well. Murder essentially means, and this is paraphrasing, that you have killed someone. Well, the state can't prove that Brandon Williams killed Thomas Arnold. And they can't prove that because they don't have a gun. They don't have any evidence, physical evidence, tying him to the scene. There's a downward trajectory of the bullet. Again, the height differences don't make that reasonable. There are 3 people there and there's only one gunshot. All 3 of them did not shoot Mr. Arnold. Who do we know carries a gun? Amir Rosario. Who do we know shoots people with that gun? Amir Rosario. And we know that because Detective Schuler came in here and testified that that's what happened to Amir Rosario May 5th. He shot someone, that person just happened to have a gun too and shot him and killed him. So they can't prove murder, and that's why they add the charges of felony murder. Call that the catch-all, because if they can't prove you murdered someone, then they're like, well, you were around the murder and you were planning on doing something illegal, so you're guilty of murder too. They weren't doing anything illegal. As much as Detective Perrin tried to tell you they were breaking into cars, they weren't. Told you they were harassing people. Nobody complained of being harassed that night. Nobody said their car was broken into. Nobody said they were carjacked. You can't have felony murder without a crime. They're saying that crime is robbery. There's no sign of robbery. Saying that crime is assault. They said there's no sign of a scuffle. They haven't presented to you any evidence that there was any scheme or agreement between these parties to commit any crime. So they can't meet their burden for felony murder. Armed robbery. Again, I know some of it's redundant. There's no evidence of an attempted armed robbery. There's no, the watch isn't pulled off his wrist, wallet's still in his back pocket when the police get there, his pockets aren't turned inside out, haven't tried to take anything. And in fact, according to police, nothing was taken, nothing was pulled. Everything is still there. They can't meet their burden because there's no proof. Aggravated assault. Again, you'll be instructed on this, but there's no proof that Brandon Williams did anything to Mr. Arnold. There's no physical evidence, there's no sign of a struggle, there's no scuffle in the beach circle, and you've heard the testimony related to that. Possession of a firearm. They don't have a weapon. Perhaps if Sergeant or Detective Perrin, I'm probably getting her rank wrong. Perhaps if she had searched someone's home, maybe Amir's home, because she had his information, if she had focused on Amir instead of arresting Malik Williams, she may have been able to get to him before this May incident happened. Could have searched his home and maybe she would have found the firearm there. She didn't bother to do that. And that's not on us, that's on the people who have the burden of proving this case. The only person who actually fled, unless you consider Hapeville fleeing, I think that's still pretty much Atlanta. Only person that fled, Amir Rosario. How do we know? They claim they couldn't find him, even though they had his phone. Amir is violent. How do we know that? He's killed in a shootout in Decatur 2.5 months after this. And he's the only person that is accused of making threats against Shaquan Crawford, although you can believe or not believe those threats. Because again, Shaquan Crawford claimed he was making threats in September when he's not even alive. Mere presence near where a crime occurred is not a crime. They're going to tell you because Brandon was on the belt line, he was behind Amir, or near Amir maybe, that he is guilty of something. There's no proof of that. And just being there is not really. Now, some other things I wanted to bring up because at some point, the prosecutor is going to give you some version of, I am trying to distract you from the evidence, right? Going to say all these things Mr. Norman is saying, just so you don't see what really happened. Well, let's talk about it. Why did I make such a big deal about the timing? They said this is 10:27. These people reacted to this shot at 10:27. This noise you hear is definitely a gunshot. Well, the reason I made a big deal about it is because not trying to distract you, just again, trying to point out the lazy, sloppy investigation. You heard that the timing on the cameras didn't all sync up. And perhaps if what we heard on that audio is not a gunshot, or those people were reacting to a dog barking, because if you remember, the people they claim were reacting to a gunshot looked over, kept walking, didn't call anybody, didn't go to see if anything had happened. So it may or may not have been a gunshot, but Detective Perrin just said, just believe. Although she's in the business of proof, we're just supposed to trust her. Now, why is that timing important? Because perhaps, and again, I don't know, I'm not the police, but if the shooting happened a little later, right? If it happened at 10:40 instead of 10:27, perhaps she would have looked at different recordings, different videos, and maybe she would have located Amir or the person who shot Mr. Arnold. and had proof. But because she decided what happened and decided it didn't require any investigation, and that's why I made a big deal about that. It's not a distraction. It's just to point out why we don't have any evidence here. Officer King, we saw, went in Mr. Arnold's pants, removed the wallet, moved the sheet several times. Again, disturbed or may have disturbed crucial DNA evidence. The scene was not secure. You heard him testify to that. Officer came up and said, "Hey, I want to see him." Lift up the sheet. Another officer came, lifted it up again. Then he took it off and threw it over in the corner. And I don't believe that sheet was ever tested as far as what we've seen here today. Just seen during this trial. And again, regarding the timing, Mr. Carlin and Mr. Ward, you saw the video. They were outside waiting for their Uber when this 10:27 shot supposedly occurred. They didn't hear anything. You heard them say that. The man who came in here who provided the WISE cameras, all those cameras that show the car in that corner, he was at home, even closer to the shot, supposedly at 10:27. He didn't hear anything. So this is, again, just to point out, again, not to distract you, as they're going to try to say, but the timing may not even be accurate. And that may have resulted, or should have resulted, in additional investigation, because the job of the police is to provide proof, not just assumptions. And again, I told you at the beginning, at opening, you were not gonna see a weapon in this case. You weren't gonna see any bloody clothes. Brandon fled all the way to Hakeville. He was not trying to get out of the state. You heard that testimony. He was waiting for his mother to get back in town to tell him what to do. Now, you have to decide this case. And the legal standard that applies to criminal cases is beyond a reasonable doubt. And that is the highest standard in any court in the United States, beyond a reasonable doubt. And again, it doesn't mean all ridiculous doubt, like she mentioned. You know, if you believe somebody may have tunneled up in from underground and done this, yeah, that's not reason. But if you, like I, don't believe that they've shown you that Brandon did anything, if you are confused, if you're unsure, if it's only possible, or if it's a maybe, then the verdict has to be not guilty. And the person that has to get you over that hump is the state and the police. And because they did a sloppy investigation and did not get the proof, they can't meet that burden. The state bears the burden of proving beyond a reasonable doubt each and every material allegation that's essential in each element of each crime they've alleged. Brandon doesn't have to disprove or explain anything. The state has to prove each and every element of what they have alleged. And they cannot do that in this case. Grave suspicion. If you just think he might have done it, that is not enough. That's what grave suspicion is. You think, a lot of stuff here makes me think maybe, you still have to find him not guilty. Because that is the burden you're working. Sympathy. Now, again, you'll be instructed on this, but it's important. Someone's dead, right? And I understand that. I understand that when that happens, sometimes you want to punish someone. But karma, the universe, whatever you want to call it, already happened. Amir is dead, killed in a shootout. You can't punish him anymore. And you can't punish Brandon Williams in his place in order to give some sympathy to Mr. Arnold or his family. Verdict must be unanimous. One of the things we talked about when we were doing jury selection is, can you stick to your beliefs when you go back in that jury room? I know everybody wants to go home. I know you've been here for several days and you want to get back there and in and out, but I encourage you to voice your opinions, talk about the evidence or lack of evidence in this case, talk about the state's burden and whether or not they've met it. And I believe they have not. And the only reasonable verdict that you can return in this case is one of not guilty against Brandon Williams. When you go in the back and consider all the evidence in this case that has been presented, or what has been presented, if you're wavering, unsettled, or unsatisfied about what has been presented, you must acquit Mr. Williams. Now, again, I told you that I stand by all of my statements in opening, and I still do. The killer is not in this courtroom, and they have not proven otherwise. There is one unreliable witness. There was a sloppy investigation. And that is why you must find Brandon Williams not guilty of all charges. Thank you.
Let's take a brief break, please. On the Department of Labor case, did y'all talk? Please come to the podium around that way. But it says that you, the claims examiner released a decision on 12/7/21 finding you not eligible for employment benefits. You appealed. You did not appear for an appeal hearing on 7/9/24. Didn't answer the phone or give a right number. But the claim was affirmed. You appealed. Hearing was set for 8/7/24. You did not appear. So there's really nothing I can do for you. I mean, have you talked to the Attorney General?
Marshal, the president comment.
Please be seated. The good news is your lunch is here. Bad news is we gotta wait a while. Okay? All right, please proceed with the second defense closing argument.
Good morning, ladies and gentlemen. He didn't have anything to do with it. Didn't have anything to do with it. Asked the third time, he didn't have anything to do with it. These are the statements of Mr. Shaquan Crawford, the state's star witness. The person who provided them with majority of the information. His statements on the stand a couple of days ago. Mr. Ross didn't have anything to do with it. Now, ladies and gentlemen of the jury, I want to begin by thanking you all for being here. I appreciate you all listening to us throughout this trial, for being diligent, for having your notepads, for taking notes on everything that has been said, for listening to everything. Now, as I said in the beginning, and I'm just saying now, the state bears the burden of proof. They bear the burden of proof that beyond a reasonable doubt that Mr. Demetrice Ross committed the offenses as they have alleged. And as Mr. Ross sits here today, as Mr. Ross has sat here before you this entire time, he has had the presumption of innocence. He has had that cloak that I spoke to you all about in my opening, that cloak of innocence. And you've heard the state as they've shown their daggers, swords, trying to penetrate that cloak. But as I stand here today before you, they haven't been able to penetrate. They haven't been able to meet their burden to say that beyond a reasonable doubt, Mr. Ross has committed any of these offenses. And so the presumption of innocence, that cloak that is surrounded Mr. Ross. A defendant is presumed to be innocent. No person shall be convicted of any crime unless and until each element of that crime is proven beyond a reasonable doubt. The burden of the proof rests upon the state, and they must prove each and every element that is material upon the indictment to prove that a crime that they have alleged, and they must prove it beyond a reasonable doubt. There's no proof upon Mr. Ross whatsoever. So while he's wearing that cloak of innocence, he's not having to fight anything off, right? Because that's a strong cloak. They have to try to penetrate that cloak. He has no burden. The burden never shifts to him. So what is beyond a reasonable doubt? A reasonable doubt is just what it says it is. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt that is based upon common sense and reason. And after giving consideration to all the facts and circumstances of this case, if you find that your minds are wavering, if they are unsettled, then that is a doubt of the law, and you must quit. But if that doubt does not exist in your mind of the guilt of the accused, then you are authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, then it is your duty to acquit the defendant. Now, Mr. Ross, as you have heard from the state, he is charged with counts of murder, 2 counts of felony murder, criminal attempt to commit armed robbery, and this is the definition of armed robbery, which the state has gone over, aggravated assault with a deadly weapon, possession of a firearm during the commission of a felony, and hindering the apprehension of a criminal. And while those words, they carry a great weight, they carry a great stigma, just hearing those words, just in general, it's not guilt. It's not guilt, it's something the state must prove. And as you've said here today, I would argue that the hindering the apprehension of a criminal, they've shown nothing of that. They've shown nothing of that, but I'll get into that later. So how does this case start? So on some point between March 25th and the early morning of March 26th, the police, they learned that Mr. Thomas Arnold has lost his life. And as we've heard from Mr. Arnold's family, as we've heard from his friends, people that knew him, he was a fine and upstanding citizen, and I am not here to take away from any of that. And I appreciate that. And I want you all to keep that in your minds. He was a fine and upstanding citizen, not here to go against it. But what we are here for today is to determine whether or not the state can meet its burden to say that beyond a reasonable doubt, Mr. Ross was involved in any of this. That's the question for us today. And so I know that we may be emotional about death just in general. I'm sure we've all dealt with it. We've all been through it. You've all had to overcome it, right? And so we have those emotions that are maybe tearing us, maybe pulling us this way, pulling us that way, right? But we have to, as we sit here today, we have to listen to the evidence. We have to take that evidence into consideration. And we have to render a verdict based upon the evidence that's presented here today, not our emotions. I'm not asking you to be emotionless. I'm just asking you to pay attention to the evidence as presented. And so that ultimate question, right? The ultimate question was, did Mr. Ross commit these offenses? Was he a party of crimes, the offenses, as the state has pointed out? I believe that as the evidence has presented itself, no. The answer to that ultimate question is no. So then we begin and get into the beginning investigations of this case. And so when this first happens, there is a news release, right? A news release that's saying that Mr. Arnold, the information that the police have been presented, that he has been pronounced deceased, who was on the belt line. This was the initial news release. And at that point, the reward for providing information or having any information was $10,000. But then, as you heard from Sergeant Parent, that increase, that reward did go to $35,000. And with that $35,000, at the point that that award was given out, we now had, at this point, now that the $35,000 reward has been pointed out, we now had a picture, right? A still shot of who they suspected the individuals to be. We now had in the news, presented to the media, that there were individuals that were going into a vehicle, going into a BMW, a black BMW. There was a screenshot of these people of interest. So all of this is already out. It's already out in the news, in the media. And so, shortly after, the same day actually, Mr. Shaquan Crawford, he comes forward. Came forward after that $35,000 reward. And so, it's kind of as I heard the testimony, as I've reviewed this, it seemed like a telephone game, right? Which is why you might have heard me objecting to hearsay, right? Because telephone game, you have the first person, they come up with a phrase, a statement, right? And then they pass that phrase or statement along to the second person. They pass that phrase or statement along to the third person. And in the end, it's a surprise of what was actually said. Right? And so that's what we kind of have here today, which is why you heard me making those objections, is because we don't have the original. Right? We have Detective Parent saying what he heard I apologize, what she heard Mr. Shaquan Crawford say and what he heard Mr. Brandon Williams say. But what we do have, right? What physical evidence, what we have been able to see has been the video recording that Mr. Shaquan Crawford did with Mr. Brandon Williams, right? And we heard that video. It was consistent with what Mr. Shaquan Crawford told to the police. He told them the telephone game, but we heard directly, right? From that video that Mr. Shaquan Crawford took. He told the police. He told them it was somebody else. He didn't mention anything about Mr. Ross giving him a gun. We didn't hear any of that. We heard directly from him. Wasn't the same thing that Mr. Crawford told, or allegedly told the police. Of course, we don't have the recorded statements of what he actually told to the police. We didn't hear any involvement of Mr. Ross in any of this. Mr. Williams was talking about somebody else. He was talking about this third party. And then we have the text messages that you all saw that were between Mr. Shaquan Crawford and Mr. Brandon Williams. No statements of guilt in those messages. And especially important, no messages between Mr. Ross and Mr. Crawford. And I know I get my names mixed up, so I apologize. But no messages in between Mr. Ross and Mr. Crawford. You never see any communication, any text messages specifically between them. Then you have the text messages that are between Mr. Brandon Williams and Mr. Demetrice Ross. All right, and you heard the state say, Mr. Brandon Williams, he at some point said another cold case. Mr. Demetrice Ross said, yes, sir. And you heard the detective parent, she explained her, or in her role as an officer, what she expects these things to mean, right? But as you sit here, right, and you all have your different backgrounds, you come from wherever you come from, your different interpretations, this or that, because everybody's different, right? We can't solely rely on what Detective Parent interprets it to me. That's why you're here. You're here to determine that, right? You're here to bring your background, your individual experiences, your unique experiences. You're here to think about that and what it could mean, what it could not mean. And this is a situation which Mr. Norman explained it, and what it sounded like, but Mr. Williams was scared. He saw his face on the news. But what did you see from Mr. Ross? The messages from Mr. Ross, they were kind of compliant, right? Just, it is, yeah, maybe, right? He wasn't necessarily taking the lead role. He was just trying to keep calm a situation of somebody that's kind of scared because you see your face on the news. And then you have the text messages from, that they said that Taboo said to Mr. Ross. It said, 911, call me fam, something. I apologize. Again, can't say what they were referring to. There's no context around that, right? So we just got that message that the state presented, right? Nothing else surrounding it, right? So what's the context? What are the things that you have not heard? That's what we need to pay attention to. We need to think about that. Think about the things that you haven't been presented. Those are the holes, right? Those are the reasonable doubt. Then you have the pictures that they said they saw on Mr. Ross's phone. And in this picture, both of them again, it goes towards, they're scared, right? You see your face on the news, you might download a picture. You might, somehow it would end up on your phone because you saw a picture of yourself, right? But then specifically, this picture of Mr. Arnold, when asked of Detective Parent, how did it end up on your phone, right? So we have the modified date for this, right? Where's the modified date? Where's the date that it was changed or deleted? It's not there. We don't know how it actually ended up on his phone. And so these are the things that you have to ask yourself, because I was trying to ask Detective Parents about the deleted message, right? Not getting a response. Everything the state asked her, she was receptive to. She could tell you this, that, and the third. Ask her about the deleted message. I don't know anymore. And again, that deleted message was after Mr. Ross had been arrested. So they get into the investigation of the case, and you heard from the crime scene tech, Officer Dunn, and his collection of the evidence. He took photos of the crime scene. He collected the shell casings. He collected the Minute Maid bottle. Right, excuse me. But what wasn't collected? That water bottle that was out there, it wasn't collected. What wasn't found? DNA, it wasn't found on that crime scene and through that collection of evidence. The shell casings, it didn't come back to any particular person, right? Any particular person with a gun. We don't get that. We don't get the gun. We don't get the DNA. No DNA of Mr. Ross being there. He wasn't at the scene. That's why you don't get it there. And then the items that were found on Mr. Arnold, as you heard Sergeant Parent testify to, it didn't appear that anything of Mr. Arnold's was taken. You saw that watch, that pretty expensive watch. It was still on his wrist, his cell phone, his wallet with ID, credit cards, cash, insurance cards. None of that was taken. And then there was a search of Mr. Arnold's home. And this was after, I believe, Mr. Sidney Ward or Steve Carlin, they had previously went into the home, but at some point, one or the other let the detectives or the law enforcement into the home so they could search the home. They went through the home, right? When they were at the home, they didn't necessarily find anything of significance, but Mr. Arnold's car was at the home, right? And so if they were trying to take a car, right, that was supposed to be in the area, how would they have seen this car? I specifically asked them, was Mr. Arnold's home, right, visible from the area of where this incident occurred? And I asked them that for a reason. Because if they were allegedly supposed to be taking keys, right, to a vehicle, you would think they might know where that vehicle is. No. It's too far away, couldn't see it. Then you have the autopsy report. Autopsy report, it can tell you what happened, right? That it was a homicide, but can't tell you the when, the who, the why. Can't tell you any of that. You don't know that from hearing the autopsy report. We're seeing the autopsy report and listening to Dr. Melissa Sims Stanley. And then in their investigation, it's like the parents' investigation and whoever else was involved with her, they did try to collect the surveillance. And they did collect surveillance video. But what's important, because they collected a lot of surveillance video, but what we don't see on that surveillance video is actual footage of the incident. We don't see Mr. Ross with a gun in that surveillance video. And these are the things that I want you to take into consideration. These are the things that I want you to, kind of pay attention to that the state's missing, right? They're missing this stuff in their presentation of the case. And so Mr. Ross, he was arrested around 10:25 on March the 16th of 2022. And so this is a video of when he was initially arrested, right? Because like I said, they didn't find any gun on Mr. Ross, right? So this is him when he is initially arrested. Can you all hear him? Let me share my sound. I apologize. Should work better.
You have to hit mute on your device and then share.
Is it working now? Yeah.
Please with award. Come to the
I thought
door.
that.
Hey, come on out, boss. Come on out. Coming. Come on, come to me. Come on. Turn around. Turn around, put your hands on your head, walk backwards. Keep coming. Yep. Keep coming. Keep coming.
All right, so this is the initial video of Mr. Ross's arrest, and I just wanted you all to pay attention to the timestamp that it was 10:25 a.m. that they went into, or they arrested and went to Mr. Ross's home.
Police, come to the door, have a warrant. Police with a warrant, come to the door. Hey, come on out, boss. Come on out. Coming. You got a warrant, come to me. Come on. Turn around. Turn around, put your hands on your head, walk backwards. Keep coming. Yep. Keep coming. Keep coming. Move back. To that way. To that way.
Is Quincy inside? How tall is Quincy?
And here I want you to pay attention to the officer going into
What do you do with a beard?
Mr. Ross's home.
Hey, police.
Are you Quincy?
Yeah.
All right,
Hey, we got contact with Quincy.
All right, so there you can see a portion of the officers going into Mr. Ross's home, and then in order to just try to quicken the time, this is another video continuation of that previous video of the officers still in that home.
Okay, let me go check real quick. They come up with a girl yet? Not down too. Huh?
And so here you can see the officers, they're still in the home. It's 10:31. They're pretty deep in there. If you can see clearly, they're inside of Mr. Ross's.
Let me go check real quick. Come up with a girl yet? Not down too. Huh?
So they're in there, and then they speak with Quincy, which I asked, I believe it was Detective Sluss, about the relationship, which I suppose it really doesn't matter, but I believe that he was Mr. Ross's brother's roommate. But anyway, they have a conversation with Mr. Quincy. And they're asking him, have you seen Mr. Ross with the gun? And so I just want you to listen to Mr. Quincy.
He's got any handguns or anything inside?
No, well, not, I ain't been in Donald's room.
Okay.
Not that I'm,
So he's been in Donald's room?
yeah, that,
Okay, and Donald works, he left for work already?
yeah, he working 2 jobs, so.
Gotcha. All
I
right.
work on.
You're not in any trouble? Donald's not in any trouble. He's got his own little trouble, so we're gonna deal with him, okay? But we're just clearing your apartment real quick, make sure there's,
No, my girl in there, she
asleep?
yeah, she was.
All right. Hey, there might be a girl inside. In your room, where's your room?
Where I went to the left.
She'll be in that room?
Yeah.
First room to the left. All right. You have not seen him with a handgun or anything?
No. I mean, I seen him in the kitchen, but no handgun.
Not with a handgun? With a handgun?
No, not with a handgun. He
Okay.
didn't have nothing.
All right. No. Cool. Just give us a minute. We'll be right on your way.
All right, and so you heard from Mr. Clancy, who was in that home with Mr. Ross, and at no point did he see Mr. Ross with the handgun, and you saw the officers go into that home, and at no point did those officers find a handgun, right? Because Mr. Ross, he is alleged as the person who buys the guns, right? So where's the gun? Where's any gun? They don't find any. And so as we've heard, the Beltline is a pretty busy area. It has a lot of foot traffic going in and out of it. And so it's hard to kind of keep track on necessarily everything that's going on in this Beltline, right? To keep up with everybody that's in the Beltline, to specify this person over this person in the Beltline, right? And so they go over the location, and they go over the location in regards to Mr. Ross's phone, right? Say Mr. Ross's phone is in the area around 9:30. Mr. Ross's phone is in the area around, it's 9:57 again, and then finally they still see that phone at 10:50. But even with the investigator testifying to the phone records, right, they can't say that Mr. Ross and anybody else, that they can't say they were in the same general vicinity. They also can't say that the records are consistent with them traveling together, right? Can't say that. And so, picture I tried to, hopefully it looks good enough. A picture of Mr. Ross's phone. They're on, and I believe and I'm not sure if y'all can see it, but the PowerPoint says 1040, but if you can see the actual phone records, it's 1050. And so where they're letting this gunshot happen was 1027. And based on these records, Mr. Ross, he's still in the area. He's not running anywhere, right? It's 1050. That they're still picking up on his phone. And so you heard testimony from Miss Edna Rivers. And her testimony didn't necessarily pertain to Mr. Ross. It's just she didn't know him, couldn't identify him, never spoke with him. He wasn't the person who had went to her home. But she did provide messages, right? She provided messages, and she said she would provide just all the recordings or anything she had regarding this case to the police. And so you see here that there is a 2-minute and 13-second recording that she alleged that Mr. Williams sent her. But where is that recording? We didn't hear it, right? She said that she provided it to the police. She said the police had their body cam on, but we didn't hear it. Where is it? This is important for you all to hear these things, right? Because you want a full picture of what's happening. And that's the state's burden. They have to prove those things. And so we have the information that the third suspect might be Mr. Amir Rosario. And I won't hit on this too hard because Mr. Norman hit on it already. But as we know, he passed away in May. And there were these allegations that, hey, he's still around in June. He's still around in September. He's still around a year later making threats. That person can't make threats. And then in regards to these threats, there are no threats that are alleged from Mr. Ross, right? Nobody's saying Mr. Ross is making any threat. And in addition to all of that, this entire time they had Mr. Ross's phone. They had, and specifically Sergeant Perrin had it since April 1st, right? Police had it since Mr. Ross's arrest on March 17th, but this taboo, his phone number was in that phone that entire time and never looked into it, didn't find out apparently maybe until after they had arrested that Malik Williams, the wrong person. But they had it the entire time. And as I stated, there is no evidence of any hindering the apprehension of a criminal. Mr. Williams, he was arrested prior to Mr. Ross. There was no indication that Mr. Williams was living with Mr. Ross. There's no indication that Mr. Ross at all stopped any apprehension, right? Nothing of the sort. State hasn't proved it. And so they've done all of this investigation. They've looked all into this case, right? They searched the crime scene. They pulled the Georgia Bureau of an Investigation and looked into everything they could find. They didn't find any DNA of Mr. Demetrice Ross. They never found a gun. No surveillance video of this incident. In the state, they haven't met his burden. He had nothing to do with it. He had nothing to do with it. He had nothing to do with it. Mr. Demetrice Ross, he had nothing to do with it. We heard from Mr. Shaquan Crawford, the state's main witness, right? He came here before you all. No alleged threats from Mr. Ross, right? And he decided to tell the truth. He decided to tell the truth that Mr. Ross, he had nothing to do with it. If I can have one moment. All right, thank you all so much for being with us throughout this entire trial. This is the last time that you all will hear from me. And so I do truly appreciate you all sitting here. I appreciate you all listening to all of the evidence. I appreciate you all considering everything. And so I do just want to leave you with this, right? I want to leave you with some lasting remarks, something impactful. I want you to keep in your mind, right? The burden that the state has not met, the burden that the state cannot make, right? The evidence that the state has not presented. And that proves that Mr. Ross, he's innocent. He never carries that burden. He is cloaked in that cloak of innocence. And we are just asking that at the end of all of this, that you find Mr. Ross not guilty. Thank you.
Let's take a brief break, please.
Oh, no, when I was.
Please be seated. Please proceed with the final closing argument of this day.
Now, I told you all that this would be the time that we get into the facts that led us here. I won't take the whole rest of your afternoon. I think 7 days we have went through all of this evidence. I want to walk back through the highlights of how they play into the elements of the crimes charged and explain to you how you have everything you need to find both defendants, Mr. Williams and Mr. Ross, guilty beyond a reasonable doubt. This is where we started.
Baby, you look like a boy. Okay, what you mean? Y'all didn't get no. What you mean? Y'all didn't get no money out of this nigga? Ain't no money, man. That nigga didn't go in his pocket, man. I said, man, God damn, man, that shit made me. I don't even want to think about that shit. Yeah, you bust the pocket. Don't shot that nigga up. Don't shot him. I caught 2 on him same night. They still ain't found me. Shit. That's crazy. So what the hell goddamn what's on there? It's like, up, man. I need to go to Texas. Where he at? I can dig it, bro. He up? That nigga up. You know what I'm saying? Me and me, we grinding. But you got other niggas with you? Shit, yeah.
Now, despite the parts that Mr. Norman wanted to highlight and bump up and the other parts he didn't, let's go through them all. Ain't even go in their end pockets. We saw the evidence of that. You saw the printout of the contents of every single thing that was in his pockets, in his wallet. His hand was still in his pocket with that watch on. But that's not what they came for. So thanks for telling us that fact. Dome shot. Dome cat. You heard Mr. Williams say it, then you heard Mr. Crawford say it to confirm. He didn't say, oh, I'm not exactly sure because it was actually Taboo who did it. I'm not sure. I'm just telling you what I heard. He didn't say that. I caught 2 of them same night. What are we referring to? I can think of what we found one of. I can think of where the surveillance led us there. And the context of who we're talking about. Mr. Crawford asks, and what about, what about what's his name? Not what about him? Not the one we're already talking about. What about what's his name? That's when he says, oh, Taboo, he up. But then pay attention to the next part where unprovoked, no question in there, he says, oh, but meat and meats. We were at. So it was Mr. Williams who named all 3 players. All 3. See, I told you the testimony of a single witness, if believed, is enough to establish a fact. They wanted you to believe that was Mr. Crawford, but it's actually Mr. Williams. That's where we start. So let's go through it. Corroboration is not necessary. It's not required by law, but let me tell you how we have it. You had Miss Edna Rivers and Miss Reese. Miss Rivers knew Mr. Williams. She said, yeah, that's him in the screenshot from the news article. Miss Reese, I never seen him before. But I can tell you he came to that house, no business being there, really didn't know why. On March 5th, I knew he had to go. And they glossed over the fact that Miss Reese said that she was present when Miss Rivers was getting the contact on March 11th about him coming back out to McIntyre. You heard that from Miss Reese, and she reached out to law enforcement while Miss Rivers remained on the phone. You heard that. Now, what motivation did they have to lie? What motivation did they have to make that up? You didn't hear anything about that. Then you heard from Mr. Crawford. Mr. Crawford didn't ask to be part of any of this. That's what it really comes down to. He got threats. He told them about the threats at the time. He came back and said, I'm still getting them. Somebody shot me multiple times. It took multiple incidents before he got to September. And as much as they try to twist the words, they asked him multiple times, well, when was this happening? It was right after somebody called my phone. Then there were the multiple shootings. And then in September is when I went to tell the police about it. Now, if you had people trying to hunt me down and hunt my family down off of something that's already transpired, off of me talking, it might take me a minute to go too. But he did it. But we'll get into the defense's thoughts on Mr. Crawford. Video surveillance. They want you to ignore every shot that you did get because you didn't have one on a dark path, no light, no camera, right for a murder. But don't pay attention to any of the rest of it where we can track them. We see them come in, we see them go, we see their route that they take. You see all that. You see the other people in the area, where they head to, where they don't. Ignore all that. Common sense. Phone communications, phone content, location data tied to the phones. I guess we'll have to talk about when we're supposed to believe it and when we're not supposed to believe it, because we got both. Williams, Ross, and Taboo, Mr. Rosario, they're all present. There's no dispute. That's one thing we can all agree on. We got that. All three were identified by Mr. Crawford when he saw the photo. Then there's the photo from the APD news release that is shared by Mr. Williams to both Ms. Rivers and Mr. Crawford separately. They're not in a group text. And then you have that same footage, including a photo of Mr. Arnold, the same one that had been published publicly, appearing in Mr. Ross's phone. There were no texts or communication between Mr. Arnold and Mr. Ross. They didn't know each other. But we're supposed to ignore that. Cell site information confirms that the phones of all three, tracking with what we were told by Mr. Williams, tracking with what Mr. Crawford then relayed back, all three utilizing towers in the area of 341 Elizabeth Street between 9:30 and 10:50. But because there's not a tower in the right next to where Mr. Arnold's body was found, I guess we're supposed to ignore that evidence. Williams, Ross, and Taboo together have a plan. Mr. Williams told it. Mr. Crawford told it again. They were going to steal cars around the Beltline and take them to a known chop shop for fast cash. That was the plan. How are we able to corroborate that? Now, we used the zoom in feature to view the same footage from State's Exhibit 9. See here, we see them coming down the street. Now pay attention to this first vehicle. We see somebody go up to that, pull on the door, then go to the black BMW. But they weren't there to steal a car. As one lies, as the lookout, as Detective Parent kind of described it, cross the street. Two, we see go in the vehicle. See something open up, it looks like a glove compartment. Light come on. Oh, but then it goes on. We have some additional footage. And now we can see exactly who that was who was going up to the first car before the black BMW. But the walking of that one who was across the street correlates with when that car comes around the corner. Remember, that was pointed out by Detective Parent. And then we see them meet back up as a group. Also pay attention that Tebu is not the one in front here, as they wanted to point out, but they meet back up as a group and head up the street. Then you saw the footage across from Pure Taqueria, where they head that way. Then you saw the footage where they head back down Bernina. Then you saw the footage where they got on the Beltline. Williams, Ross, Tebu had a plan to steal a car and take it to a chop shop. The only thing not found on Mr. Arnold were a house or car keys. The only thing that would fit into the plan. But we're supposed to ignore that. Mr. Williams, Mr. Ross, and Tebu, they have the opportunity. You can see that by the timeline that was created. After we watched their route that took them over here, saw them wait, we watch this as they advance and take off at the corner, headed towards the beach circle location. And they are the only group of individuals you do not see on any camera footage again. Y'all can count how many cameras, how many angles we showed you. You can count how many times we saw, well, what about this person running in the yellow shirt? Well, here they are running up Elizabeth. They came from skate park, there they are. What about the man who didn't take the path and he crossed over by the grass? That's so crazy because you can actually see him walk past the next camera on that side of the belt line and then curve around behind Bernina. It's not beyond all doubt, it's beyond a reasonable one. Then we capture Mr. Arnold walking right past this location with his shadow following that. We see the final minutes of Mr. Arnold. Then we don't see, but we surely hear the final moment. 2 minutes later, less than if we're counting seconds, matching up with how long it took Officer King or Rachel Whitlark or Jacqueline Garner to make it from that corner of Elizabeth and Bernina to Beach Circle. You heard multiple people talk about how long it would take them. Running, walking, either one. Let's talk about the behavior after. Looking at Mr. Williams. His conversations with Miss Rivers, also who he refers to as E. is very telling. Your shit don't even show up on the map. Let us come for the weekend, just me and my little brother. We know it wasn't his older brother, which is this River's children's father for older children. Me and my little brother. He called me, missed a call. All jokes aside, this is life or death. I can't text it. Please. We saw him text everything else. Hey, boo, I'm at the hotel, all that. Life or death, but I can't text it. You want to see me go back or like? Well, you heard from Mr. Crawford where he met Mr. Williams. You can take that as circumstantial evidence. And then we have the news release that you saw exactly where that YouTube link went to. That is consciousness of guilt. Then we have Ross and Mr. Williams, the two of them communicating. This is pulled from Mr. Ross's phone. That same image we had and what was shared by Mr. Williams. Just shared with Mr. Ross or on Mr. Ross's phone. Then we have their communications. 911, call me ASAP, brother. 911. Cut your location off too. And let me go back to that one. Gotta survive till then. They don't have a name. They surely didn't. That was in the news release. They didn't have a single name. Not at that point. Only moving at night. Remember, they didn't try to contact you. Didn't go contact him, house or anything. Well, he's not moving at night. Cut your location off too. Nah, bro, we just have to be cool. We gonna survive this. But they were scared. Yeah, you right, brother. Another cold case. Yes, sir. I'm about to send you our secret spot. Plan B. Cool, I got you. The context when this is shared, what it correlates with, the phone evidence. The secret spot, it's in the middle of nowhere, about 10 minutes from E, Edna Rivers. She gonna let us get her car while we park you in your car in the deep of her yard, because again, he was trying to work out coming for the weekend, just him and his little brother. Cool, I got it, bet. All right, write it down. Put it for safekeeping because I'm about to delete it. Same way I'm about to delete my Facebook, which is what you told Miss Rivers. That's the two of them. Conduct, companionship after the crime. And then let's just look at Mr. Ross's phone. Just Mr. Ross. Communications on 2/25/2022. Throughout that day, we see him talking to Taboo. Gave you the number, did the search of the number, records came back. That's Mr. Rosario. We all agree Mr. Rosario is the third. Okay. Take me on to the 26th and the 27th. All that conversations with Taboo, who they absolutely want you to think was involved and had to do with this murder. Okay. Then we have the searches. Channel 2 News, Channel 2 News again. And you saw where that report came from. One of them. And then the last entry we had there was a call on the same day he was arrested to Taboo. Or from Taboo. And we can't forget that picture that he had of Mr. Arnold in his phone. Not a contact, not a text message. We know Mr. Arnold didn't send it to him. But they want you to ignore consciousness, guilt. Now, a little bit of the science that they want to get to. You heard from the medical examiner, Dr. Sim Stanley. She talks about the cause of death was a gunshot wound to the face. It entered through the nostril. That's why it was so hard when they found the body to see and determine what had happened, because the unique way it ended up entering the body and then exiting. But she went through all the different portions of his body that bullet struck before it exited. She also, even though they want to say, wouldn't that be the direction that the bullet was fired, is downward? She said that's the direction it took once it was in the body. The important distinction, we keep trying to gloss over that. She answered it very directly. And the most important part is that this is not, what was actually press contact wound, nothing of that sort. It was an indeterminate range, which she clarified meant that it's usually a range of 3 feet or more. 3 feet or more. And the manner of death, homicide. We don't know who done it. Now, this is one of the things I guess that even the defendants didn't agree on, because it started out, we don't know who done it. Now it turned into Mr. Rosario did it, but by himself apparently. But we do. We know who did it. They acted as a group, as parties to a crime. If you didn't want to just believe Mr. Williams when he told you, it's corroborated by technology, by testimony, by crime scene investigation, and by the defendants themselves. The technology is the phone records. You can't say at one moment, they should have had those phone records. And let's be clear, the number for Taboo came from the cell extraction from Mr. Ross's phone that was gathered at the point at which he was arrested by fugitive, that then had to submit it to Detective Parent, who then had to submit it to the crime lab, who they're the experts. She told you multiple times, I don't do it. I look at the report. And then she had to get that back. And then she had to subpoena the phone records. That's an important distinction. But remember, she also wasn't investigating anything. She rushed. She didn't wait for one step or the other. It was just a rush to judgment. Somehow we have both. Mr. Williams' video. Not going to play it again. You've heard it plenty of times. The text conversations and the searches we both looked at. It is the defendant's own actions and words that lead us here. All the phone does, all the phone records do, as you heard from Detective Sluss, is build upon that. That's all they do. And looking at what it built upon, that was exactly that. At 9:28 p.m., Mr. Williams' device receives an incoming call. Look at where that tower is. At 9:29 p.m., Taboo's device receives an incoming call. Utilizing same sector, same tower, the azimuth is going in the same direction. Ross's device interacts with the network using timing advance. He explained that. Different direction, however, look at the point at which the tower would be. All utilizing the same tower altogether. They are utilizing towers in close proximity to the crime scene at that point. Again, at 9:57 and 10:05, specifically just looking at Mr. Ross's activity and Mr. Williams' activity, building upon that, utilizing towers in close proximity to the crime scene. And that tracks with what he told us. That makes sense? Tracks with the surveillance. And then here we have after the murder. That's at 10:32. Looking at Tabu's device, making an outgoing call. 10:40, Brandon Williams' device, interacting with timing advance yet again. And then 10:40, Demetrice Ross's device, interacting with timing advance yet again. And at that time, they're still in that close proximity to the murder. It's only building upon what was already there. The testimony that you heard, the plan to steal a car and take it to a shop. That's corroborated by the images that we see. Dome shot or dome cat. Detective Perrin had to ask what that meant. Shot in the head. Wasn't part of the media release, but is corroborated not only with what Mr. Williams said, but the autopsy. And say it was, he fired 8 shots into the man. It was a whole fight. It was a shootout. Distinctively knew it was a single shot to the head. Didn't even go in his pockets. We went through that. You saw that. And Meat's gun. He used Meat's gun because he didn't have a record. He could just stop by saying, hey, it was Meat's gun. Brandon used it. No. He then gave you the extra why it was Meat's gun. Because he didn't have a record. So he could get them from pawn shops. You heard Detective Perrin explain in Georgia, you don't have to register a firearm. This is a 9mm handgun we're talking about. There's no requirement that it needs to be registered, which means very hard to trace. Only time it would come up as traceable is if there was a NIBIN on that national database hit. Now you heard Detective Perrin say, we entered these shell casings or that one single shell casing from the scene into NIBIN. No hits. She came in here now in April of 2025 and told you no NIBIN hits. Then the defense brought in a detective, not the lead detective. I don't know where he was, who would have known for sure, but they brought in the assisting detective on Tabu's murder that involved a 9mm shell casing. Good to know, because you know what steps were followed there. They entered the shell casings into NIBIN. And so when I asked him, so are you aware that the shell casings came back to other cases, but they didn't include this one? Oh, I don't know that one. The lead detective probably did. That's who handles that. That's why Detective Perrin knew. And they didn't have to call any witnesses. They did not have a burden at all. They did not have to present a shred of evidence. But in using the same subpoena power that we have to get people here, they chose to get the assisting detective who would not handle NIBIN, who couldn't give you that definitive answer. There's no NIBIN hit because that is not the firearm. It's not. In the scene, single shell casing, he still has his belongings in his hand in his pocket. It's an indeterminate range, 3 feet or more. So if you make it past the fact that they weren't arrested until, a week and some change for Mr. Ross after this in different clothing and different items, there's also a distance. So there's plenty of explanation why there isn't forensic evidence in this case. It's unfortunate. You heard about all of the ways we tested to try to see if it was there, and it just wasn't. And very important. Well, it was busy on that belt line and all these people, somebody would have seen it and they must have been tampering with the scene and all that. You heard from Miss Gardner that at that time of the morning, at that time of year, it would have been dark until they were making that run. That's why their earlier running group didn't see anything. Even if they took the same path as pitch black. Everything corroborates the words of Mr. Williams that Mr. Crawford relayed. He gave us a play-by-play He involved the name Meat, not Mr. Crawford. You can tell from Ms. Crawford testifying, he really didn't have any issues with Mr. Ross. And he told you that. Meat told me he didn't have anything to do with it. That's a very important distinction. And I didn't expect Mr. Crawford to understand the parties to a crime, or that even if you don't fire the final shot, if you provide the gun under law, you are guilty as party to a crime. But I didn't expect Mr. Crawford to do that. We don't coach people on what to say. They come in, they tell the facts as they are. That is it. That's my job to explain that to you all. It's not a fact, it's the law. And then Mr. Ross being in Morrow, you all saw the footage. I won't play the footage again, but you saw the footage of his arrest and the part where Sergeant O'Hare goes to talk to Quincy, who he kept saying is Quincy here, Quincy, you're Quincy. Okay, it's Quincy's apartment with Donald, who is listed as Demetrice's brother. The only Donald that you heard about was Miss Rivers' children's father, Donald Williams, Brandon Williams' brother. But it was not his apartment. So no, there wasn't this extensive search or anything there. But let's just take some time to go through the defendant's arguments. Saying they're not involved, yet they're the only group that can be traced on that footage anywhere. They have communications with each other about this case, about the homicide, about Mr. Arnold, about the plan to lay low. The defendants are merely present. Mr. Williams claimed to be the shooter. That was very clear. And then added that Mr. Ross gave him the gun. Now, Mr. Crawford was very clear in the fact that the least connection he had to anybody here was Taboo. So if he is such a liar, he made all of this up, why would he implicate the two people he do the best? He could have said Taboo did it, he wanted to go and steal out. I know that Brandon and Demetrice, they just happened to be out there with them, but you know, he was the one that was a shooter. He brought the gun with him. He always carries a 9, you know. He didn't say that. What motivation does he have to put himself in the crosshairs, avail himself at that point to threats that continued on for months after this? It doesn't make any sense. And again, we don't know who done it. We got to ignore what Brandon said, ignore all the evidence, everything that points to Mr. Williams and Mr. Ross guilty of this crime. Now let's talk about some of the things Mr. Norman said for Mr. Williams' specific defense. Starting with, it was Amir Rosario who did it. Taboo. And yet, Brandon Williams knew all the specific details. When it was, that Meat was also there. He was there. The connection that everybody had. And again, Crawford could just put all this on Taboo and wouldn't have had to implicate his friends at all. It doesn't make sense. But Mr. Crawford is the unreliable witness, apparently. Not Brandon Williams. Brandon Williams, you want me to ignore what he says on the video. But also, I can't keep up with who the unreliable witness is. Mr. Williams' video is reliable. Mr. Crawford was just relaying exactly what he was told. And it was important because he went and told it to the Hateville police officer, talked to Detective Parent, then went back and said, I'll let y'all know if I get anything additional. And then he got the video of Mr. Williams saying it himself. But they want to tell you that's not enough. Can't believe it. And so much about talk about this reward. I don't really know why it keeps coming up. Miss Crawford sat here, Miss Rivers, Miss Reese. Not one person said, did you get the reward? Okay. Rushed investigation. This just happened too fast and they were just rushing to do it. There's that water bottle at the complete back of Beach Circle, away from the one-way in and the one-way out to the path that you would have had to take to get to and from that crime scene. You'll have the photos back there. Pay attention to where the Minute Maid bottle is, which is right by the entrance to step up to where the body is. Collect it out of precaution. That's what they should do. But in his presentation, Mr. Norman had to zoom in and crop to get where that water bottle was at the very back. Let's also keep in mind, we have footage of them walking around. There was no water bottle. They didn't have a water bottle. It wasn't relevant, but apparently you got it both ways. One, you either don't test things and that's a problem, but two, you spend all these resources testing and don't find anything. Can't have it both ways. Also, apparently we're supposed to get warrants to knock up and down everybody's mama house. That's apparently what we're gonna do. We're going to knock down Quincy's door and go in there, even though he said he hadn't seen Mr. Ross with a gun in there, even though it's his residence, even though he said his girls in the pathway there. He had been cooperating. There was no reason not to believe him. Mr. Quincy didn't do anything wrong. But we should have got a search warrant for there. Should have got a search warrant for Mr. Williams' mama's house, even though it shows that he's moving in between Miss Rivers, a Motel 6 on Virginia Ave, and the La Quinta. Okay. Then there is the black BMW with the parking ticket, and they should have known exactly who it was and all that. Well, she released it to try to figure out who it was. It was ATL Mobility Plus who gave the ticket. But at the end of the day, you don't see a charge on this indictment related to breaking into the BMW. So when it comes to a red herring, I guess that's it. The point is to charge them for the crimes that we can show beyond a reasonable doubt that they committed. We can give you our observations. We can show you what we do have related to that black BMW. But if we did not speak to the owner of the black BMW and confirm, hey, can you please testify and let us know that that car was broken into? That doesn't reach beyond a reasonable doubt. And so that's why it's not on the indictment. But again, we gotta have it both ways, I guess. And then parent had the phone numbers and the records and everything at one time and still got it wrong. And Mr. Williams sat there for 4 months, but they want you to feel good about it. I don't feel good about any of this. I don't come and do this job because it makes me feel good. I didn't ask to be here. Mr. Arnold didn't ask to end his life and to have his final resting place be Beach Circle. Nobody wanted to be here and nobody planned to be here. It was Mr. Ross and Mr. Williams's actions that led us here. I want to be very clear in that. It is a good thing that those records were used to exonerate and clear Mr. Malik Williams. I will not apologize for the fact that that was done correctly. Of course, we wanted to go sooner. Of course, we hope it had never happened. But there is an investigation because every piece has to be examined. Because we have to be held to our burden of proof beyond a reasonable doubt at all stages. And by doing the job, now apparently that's an issue. I can't keep up. But I'll tell you, the phone records did exactly what they're supposed to do, which is tell the truth of what happened that night. And that's what they did at every turn. And then, of course, all of this, I guess, was made up by Mr. Williams because he was scared. I know y'all heard the music at the beginning of that video. And before he started talking, it was a little bop going on. It wasn't really translating to me as scared. But I don't know. That's Mr. Norman's take. Maybe that's what y'all saw. Doesn't really track a scare. That, his phone messages, his conversations, even the videotape of while he's being arrested. Not really saying scared. And you won't find any evidence of that in his phone and records anywhere else. So then let's talk about Mr. Ross's defense that Ms. Hemingway presented. Okay, he had nothing to do with it. Okay, but he's here because Mr. Williams said he did. Let's start there. He specifically says, I shot, but Meek gave me the gun. And Meek got it because Meek can get it with no tracking. He's got no history. Great, can't be traced. We've already heard the testimony as to why. And again, in that video of Mr. Williams, Mr. Crawford does not bring up the name Meek. He doesn't bring up any names. He says, what about, what's his name, old dude? And that's how he says Taboo. Mr. Williamson says Taboo. But then Mr. Williams goes on to say meat and meat. Meat and meat. So then let's get on to Mr. Crawford. Even the defendants themselves can't agree. Am I supposed to believe that he's a liar? Or am I supposed to believe when he says, me have nothing to do with it? Which one is it? Which one is it? There's absolutely no communication with Crawford between Mr. Ross and on his phone, except for the phone call that we had for 2 minutes and I think about 19 seconds or so on March 12th. Heard about that with Detective Parent. Okay. You saw in the messages between Williams and Crawford that Crawford provided to the police, call me with phone number. No communications. Okay. What about the text between Brandon and Taboo? Call me for real, it's an emergency. We're supposed to ignore that because he had nothing to do with it. The same images of Mr. Arnold, the Channel 2 News search, the calls with Taboo that continued going back and forth, some missed, all the way up until the 16th when he was arrested. But he had nothing to do with it. And we already went through the home. It wasn't Mr. Ross's home. He was at a completely different location in Morrow where he was staying in the room of Donald, Quincy's roommate. For a few days, he specified, which tracks right around Mr. Williams' arrest, right around the press release and all that. But he had nothing to do with it. See, the defense wants you to believe that this was anything other than what the defendants told you it was. That's what they want you to do. Ignore all your common sense, your eyes, your ears, and believe that this was anything else other than exactly what you heard that it was. Amir Rosario did this, and he did it alone. There was no knife-in hit from those shell casings, which happened, that shooting, his death happened in May 2022. These shell casings, this single shell casing from this would have been entered into knife-in already. They would have been tied together. Here in 2025, Detective Parent could sit here and tell you there was no knife-in hit. It is not the same gun. And then he did this and he did it alone. Just like he did it alone in the shooting death in the case where he was killed. No, there was a difference. I can't say that he did do it alone in May 2022, and that proved pretty unsuccessful. Because he was used to having two people at his side. But we know by May 2022, they were a bit unavailable. And again, they're scared. They are terrified, but that's nowhere in these messages that nobody could see. See, it's the times where no one's watching or you think they're not, where the truth is revealed. I don't see a thing about them being scared. The defense wants you to ignore the same evidence they want you to pay attention to. That doesn't make sense. Crawford is a liar. Whenever he's talking about Williams and Ross being involved in this murder. But when he says that Table is unstable and he didn't really mess with him like that, now you should believe him when he says that part. He was telling the truth there. But everything else, he's a liar. Williams is talking about Rosario the whole time during that video recording. Even though he makes it very distinct when he says, I got two bodies. Okay. The eye was very clear. Now, back to my stories. I'm sorry. But I grew up loving sea creatures. I love it. If I retire from this job, I'll go work in an aquarium. But one of the most interesting creatures is a squid. See, when the squid is being approached, closed in on, their back is up against a proverbial wall, they release ink to distract, deny, deflect, so they have enough time to get away. What you heard was denial of what you see before you, what you heard before you, what you were able to review. Deflection. Look at the man who's not here. He died. How convenient. He did all by himself. Distract you from the part that they played and we have evidence of. They want to distract you from seeking the truth of what happened on February 25th, 2022. That's what this comes down to. But your common sense is the greatest tool. The evidence shows beyond a reasonable doubt that Mr. Williams and Mr. Ross are guilty. And with a guilty verdict, you are not telling them anything that they don't already know. Anything that they didn't know from when that walk of Mr. Arnold fatefully ended at 10:27 p.m. that evening. Because he began it as the man here, dog loving, spending the night with friends, parting ways, getting a little back relief. That's how he left at 10:25 p.m. However, at 10:28, by 10:28, he became case number 22-0526. And because of Mr. Williams and Mr. Ross's actions, that's how we have to talk about him now. That's how they wanted you to remember him. I am asking that you follow the evidence. What you will have back there, if there are any videos you would like to see again, anything that you're not able to access, send out a note and let us know. Because if you follow the evidence and you go to the truth of what happened, it will lead to the decision that is ultimately yours, and the decision that speaks as to what we will and will not tolerate in Fulton County. This was a crime that they wanted you to forget, but it is a crime that you cannot forget. Not here, not in Fulton County. And if you follow the evidence, it will lead to a verdict of guilty for both defendants on all counts. Thank you.
All right, we're gonna feed you lunch now, okay? So let them step back and just eat as soon as you can, please, okay? Then we'll come back for the charge of the court.
Authorize the clerk.
What we start? Yeah, finish going over the exhibit.
Wait. Oh, I'm sure now. I did, never mind, it's dead. Had two thumbs. I'm not crazy.
Don't get the full cost for the further.
So
have reviewed, lawyers have reviewed, for both parties have reviewed the verdict forms. Are they acceptable?
Yes, Your Honor.
Ms. Hemingway?
Yes.
All right, so there's no exceptions to the verdict forms. What about the jury charges? Everybody got the ones they wanted, right?
Yes, Your Honor.
No exceptions by the state. Any exceptions by the defense?
Not on behalf of Mr. Williams.
Not on behalf of Mr. Ross.
All right, let me have a jury.
Your Honor, before we do that, we just wanted to put on the record, the parties did review the evidence. We do have that prepared to go straight.
So the evidence has been reviewed and by stipulation, it's complete.
Yes, Your Honor.
Is that correct?
Yes, Your Honor.
Yes, Your Honor.
All right, let me have a jury, please.
What else you got, Mr. Long?
No, I just want her to move it into
Okay.
She's doing it.
And their cell phones will be going in the bin once they.
Mhm.
Judge. Hey.
Yeah.
Oh.
All right.
Cause you can.
Please be seated. I trust everybody got the lunch they wanted.
Yeah, thank you.
Good. That's courtesy of the taxpayers of Fulton County.
We spoke about that.
Did you? If y'all want to make any contributions, you may. You can use that out of your $25 a day. Now is the time where the court will give you the charge of the court, which is the applicable law. The grand jury has indicted the defendants with the offenses of murder, felony murder, criminal attempt to commit armed robbery, aggravated assault with a deadly weapon, possession of a firearm during the commission of a felony, possession of a firearm by a convicted felon, and hindering apprehension of a criminal. The indictment states the exact offenses. Please read it carefully. The indictment was returned into court on June 7th, 2022. To this indictment, the defendants have entered pleas of not guilty, and this makes the issue of which you have been selected, sworn, and impaneled to try. I caution you that the fact that the accused has been indicted, the accused have been indicted by the grand jury is no evidence of guilt. You should not consider the indictment as evidence or implication of guilt. Neither is the plea of not guilty to be considered as evidence. The defendants are presumed to be innocent until proven guilty. The defendants enter upon the trial of this case with a presumption of innocence in their favor. This presumption remains with the defendants until it is overcome by the state with evidence which is sufficient to convince you beyond a reasonable doubt that the defendant or defendants are guilty of the offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime or crimes charged beyond a reasonable doubt. There's no burden of proof upon the defendants whatsoever, and the burden never shifts to the defendants to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It is a doubt of a fair-minded, impartial juror, honestly seeking the truth. It is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, a conflict in the evidence, or any combination of these. If after giving consideration to all the facts and circumstances of this case, your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you should acquit the defendants. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendants. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendants. You must determine the credibility or believability of the witnesses. It is for you to determine what witness or witnesses you will believe and which witness or witnesses you will not believe if there are some you do not believe. In passing upon their credibility, you may consider all the facts and circumstances of the case, the witness's manner of testifying, their interest or lack of interest, their means and opportunity for knowing the facts about which they testify about, the nature of the facts about which they testify, the probability or improbability of their testimony and the occurrences which they testify about. You may also consider their personal credibility insofar as it may legitimately appear from the trial of the case. To impeach a witness is to prove that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified, proof of general bad character, proof that the witness has been convicted of a crime, of a felony, proof of contradictory statements previously made by the witness about matters relevant to the witness testimony and to the case. If it is sought to impeach a witness by proof of general bad character, proof that the witness has been convicted of a crime, of a felony, proof of contradictory statements previously made about the witness about matters relevant to the witness testimony and to the case, proof of the general good character of the witness may be shown. The effect of the evidence is to be determined by the jury. If an attempt has been made in this case to impeach any witness by proof of contradictory statements previously made, you must determine from the evidence whether any such statements were made, whether such statements were contradictory to any statements the witness made on the witness stand, and whether such statements were relevant to the witness's testimony and to the case. If you find that a witness has been successfully impeached by proof of previous contradictory statements, you may disregard that testimony unless it is supported by other creditable testimony. The credit to be given to the balance of the testimony of the witness would be for you to determine. It is for you to determine whether or not a witness has been impeached and determine the credibility of such witness and the weight the witness's testimony shall receive in the consideration of the case. Members of the jury, it is my duty and responsibility to ascertain the law applicable to this case and to instruct you on that law by which you are bound. It is your responsibility to ascertain the facts of the case from all the evidence presented. It then becomes your duty and responsibility to apply the law I give you in the charge to the facts as you find them to be. These defendants are charged with crimes against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act or omission to act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be in your discretion inferred when it's the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. These defendants will not presume to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act or acts for which the accused are being prosecuted. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks by the attorneys, or questions asked by the attorneys. Direct evidence is that which may be seen or heard, or otherwise directly sensed, such as by smell or taste or touch. It may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence by inference points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. Whether dependent upon direct evidence or circumstantial evidence or both, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. There's no rule that either circumstantial or direct evidence is stronger than the other, if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the jury to decide. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant in a criminal case The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. You should evaluate such testimony as you would that of any other witness. However, the defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. Sometimes evidence is admitted against some parties and not others, or for some counts and not others. Such evidence may be considered by the jury against that party and only for the counts for which the evidence is limited and not for any other purpose. Knowledge on the part of a defendant that the crimes in this bill of indictment were being committed and that the defendant knowingly, intentionally participated in or helped in the commission of such crimes must be proved by the state beyond a reasonable doubt. If you find from the evidence in this case that the defendants had no knowledge that a crime was being committed, or that the defendants did not knowingly and intentionally commit, participate, or help in the commission of, and was not a conspirator in the alleged offenses, then it would be your duty to acquit the defendants. On the other hand, should you find no doubt that the defendants had knowledge that the crimes in this bill of indictment were being committed, and that the defendants knowingly and intentionally participated or helped in the commission of it, then you would be authorized to convict the defendants. A jury is not authorized to find a person who was merely present at the scene of the commission of a crime at the time of its perpetration guilty of consent in and occurrence in the commission of the crime unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of that crime, or participated in the criminal endeavor. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required the testimony of any witnesses, expert or otherwise. Testimony of an expert like that of all witnesses is to be given only such weight and credit as you think it is properly entitled to receive. The law provides that criminal action shall be tried in the county where the crime was committed, except as otherwise provided by law. Venue, that is, that the crime or crimes were committed in Fulton County, is a jurisdictional fact which must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses. This may be done by direct or circumstantial evidence or both. Every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime only if that person directly commits the crime, intentionally helps in the commission of the crime, intentionally advises, encourages, hires, counsels, or procures another to commit the crime, or intentionally causes some other person to commit the crime, such circumstances that the other person is not legally guilty of any crime either, in fact, or because of legal incapacity. A conspiracy is an agreement between two or more persons to do an unlawful act. And the existence of a conspiracy may be established by proof of acts and conduct, as well as by proof of an express agreement. When persons associate themselves in an unlawful enterprise, any act done by any party to the conspiracy to further the unlawful enterprise is considered to be the act of all of the conspirators. However, each person is responsible for the acts of others only insofar as such acts are naturally and necessarily done to further the conspiracy. Whether or not a conspiracy existed in this case is a matter for you to determine. Presence, companionship, and conduct before and after the commission of the alleged offense may be considered by you in determining whether or not such circumstances, if any, give rise to an inference of the existence of a conspiracy. The defendants are with the offenses of murder, felony murder, criminal attempt to commit armed robbery, aggravated assault with a deadly weapon, possession of a firearm during the commission of a felony, possession of a firearm by a convicted felon, and hindering apprehension of a criminal. The court will now define the offenses for you. For malice, murder, the state must prove that the defendants caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification and without excuse. You may find malice when the circumstances show that the defendants acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all of the circumstances of the killing show an abandoned and malignant heart. You don't have to prove premeditation to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's minds. Malice may be formed in a moment and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act of the killing and moved the defendants to do it, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendants acted with malice to prove felony murder. Criminal attempt to commit armed robbery, aggravated assault, and possession of a firearm by a convicted felon are all felonies, which I will define for you shortly. You may find the defendants guilty of felony murder if you believe that they caused the death of another person by committing any one of the felonies of criminal attempt to commit armed robbery, aggravated assault, or possession of a firearm by a convicted felon, regardless of whether either defendant intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in the death, regardless of when the death ultimately occurred. A person commits criminal attempt to commit armed robbery when, with intent to commit, that person performs any act that constitutes a substantial step toward the commission of the crime of armed robbery. For armed robbery, the state must prove that the defendants took another person's property directly from another person or from the immediate presence of another person by using an offensive weapon and with the intent to commit theft. An offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. A person commits simple assault when that person attempts to commit a violent injury to the person of another. For aggravated assault with a deadly weapon, the state must prove that the defendants assaulted another person with a deadly weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendants attempted to cause a violent injury to the person. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. Possession of a firearm by a convicted felon. For possession of a firearm by a convicted felon, the state must prove that the defendant possessed a firearm after having been convicted of a felony. Burglary in the first degree is a felony. For purposes of this offense, a firearm includes any handgun. For possession of a firearm during the commission of a felony, the state must prove that the defendant had a firearm on his person or within arm's reach of his person while committing the felony, which is one of the following: murder, felony murder, criminal attempt to commit armed robbery, or aggravated assault with a deadly weapon. For purposes of this offense, a firearm includes any handgun. Possession, actual and constructive. The state must prove that the defendant possessed the firearm at issue in this case. Possession may be either actual or constructive. It must also be either sole or joint, Actual possession means that at the time of the alleged offense, the defendant knowingly had direct physical control over the firearm. Constructive possession means that at the time of the alleged offense, the defendant did not have direct physical control over the firearm, but did knowingly have both the ability and the intention to exercise control over the firearm. Joint possession means that the defendant shared possession of the firearm with at least one other person, the defendant. A person commits the offense hindering the apprehension of a criminal when, with intention to hinder the apprehension or punishment of a person whom he knows or has reasonable grounds to believe has committed a felony, he harbors or conceals such person. If after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendants in Fulton County did on or about February 25th, 2022, commit any of the alleged offenses, you would be authorized to find the defendant or defendants guilty. And in that event, the form of your verdict would be, we, the jury, find the defendant guilty of the offense then under your consideration. If you do not believe that the defendant is guilty of any of these offenses, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendants. In which event, the form of your verdict would be, we, the jury, find the defendant not guilty. You must make a determination as each count separately. Though you may consider all the evidence as a whole, conviction of one defendant does not necessarily require conviction of another. You, the jury, must determine the guilt or innocence of each defendant separately. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, economic status, for or against either party. You are only concerned with whether or not the defendants are guilty or not guilty. You are not to concern yourselves with punishment. Whatever your verdict is, it must be unanimous. That is agreed by all. The verdict must be signed by one of your members as foreperson, dated and returned to be published in open court. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Talk with each other and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You're also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules not only apply to in-person communication, but also to communication or research using cell phones, text messaging, website, blogs, or social media of any kind. By no ruling or comment that the court has made during the progress of the trial has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendants. Now, here's the point where we will determine who the alternate jurors are, and we ask that you, all of you have to give up your cell phones during the deliberations, including the alternates. We ask that you retire to Judge Carnicel's jury room, and the other 12 will be, Miss Woods will help you get to out the back door to Judge Carnicel's jury room. Juror number 59, Bobby Hester. Juror number 65, Michael Maloney. Juror number 68, Kevin Catteville. Juror number 75, Nathan Ward. Please, they'll come back there and they'll get your cell phones. They're going to give you the evidence. We're going to give you the verdict forms, one for each defendant, and the charge, the physical charges that I read you. And then, Ms. Woods, if you'll go back there and take Mr. Hester, Mr. Maloney, Mr. Capdeville, and Mr. Ward to Judge Carnicel's jury room. And then Deputy Ham, please collect the cell phones of all 16. Okay? You may retire to the jury room. If you'll go back here. Here you go. Hey, Candace, I need the staples. Do you have a staple? So the first note I'll mark is Court's Exhibit 1. And then we got Court's Exhibit 2. No, Court's Exhibit 2 and 3.
Yes. What was the previous question?
Wow.
Could we please see video of Brandon Williams' dome cap? I caught 2. Shaquan Crawford transcript of testimony. Well, we can't give him the testimony, but we can let him see the video. What about a copy of Detective Parent's report with Crawford interview?
I don't believe they get that.
I don't think they get that either.
I don't get that either.
What is your position on the video?
My position on the video is, I'm fine with them watching it, but given the hour, Your Honor, I'd ask that we show it to them and then release them so they don't feel.
But I'm going to ask them what they want to do.
Thank you, Your Honor.
All right, let me have a jury, please. Let me see those, please. Thank you. Can you have that video ready for me?
It's up.
Please be seated. We apologize for the delay.
Oh, yeah, we're missing a few.
We're missing a couple.
Now we're switching it up.
All right. So I have your questions here. One I have labeled as Court's Exhibit number 2. Could we please see the video of Brandon Williams' dome cap? I caught 2. And the answer to that is yes. Okay. The second one is Shaquan Crawford transcript of testimony on the stand. The answer to that is no. You have to collectively remember what his testimony was as a group. Court's Exhibit 3, copy of Detective Parent's report with Crawford interview. Same answer is no. Same. You have to remember your collective memories. Please play the interview. I mean the video.
Your Honor, for the record, this is State's Exhibit 98.
Baby, you look like a boy. Okay, what you mean? Y'all didn't get no. What you mean? Y'all didn't get no money out the money? Ain't got no money, man. That nigga didn't go in his pocket, man. I said, man, God damn, man, that shit make me. I don't even want to think about that shit. What happened? He busted pocket. Don't shot that nigga up. Don't shot me. I caught 2 on him same night. They still ain't found him. Shit. That's crazy. So what the hell goddamn what's called that? The taboo up, man. That nigga finna go to Texas. Where he at? I can dig it, bro. He up? That nigga up, man. That's what I'm saying. Me and me, we grinding. But you got other niggas with you? Shit, yeah.
Okay. Please retire. Do y'all want to try to reach a verdict tonight, or do you want to come back tomorrow?
I can't come back tomorrow.
All right. Well, let's continue to deliberate. Okay.
Okay, fine.
Yeah.
All rise for the jury. Tell him something. Also, the president counsel.
Please be seated. Are you the only one that can't come back tomorrow? You can't either?
I'm traveling on Friday.
Okay, you're leaving Friday?
I have to get myself ready tomorrow.
Okay, what? Okay, you can't come tomorrow?
No.
And you can't. But I want to make sure that nobody rushes a verdict based on the fact that two of you cannot come back tomorrow. So I want both sides to get a fair verdict based on the evidence and the law and fair and full deliberations. Okay, I don't want anybody rushing to a verdict. Now, with that being said, we all want a fair verdict. Is it a situation where I should send you all home now and replace these two jurors?
I think we're close.
You think you're close? But everybody understands, I don't want anybody rushing because they can't come back tomorrow. Is everybody okay with that theory?
Yeah.
Okay, all right, we'll give you some more time. Thank you.
All rise for the jury. All rise for the jury.
Did we bring the alternates?
All truly present, calibrate.
Got everybody? No, we don't. All those seats need to be full.
He just ain't go back to leaving.
I keep going down one more, please. One more.
There we go.
Please be seated. Ladies and gentlemen of the jury, did you elect a foreperson?
We did.
Will the foreperson please stand? Have y'all reached a verdict?
Yes, Your Honor.
Was it unanimous?
Yes, Your Honor.
Please publish the verdict by reading it in open court. The verdict,
For each individual,
each individual verdict.
for Brandon Williams, count one, we the jury find the defendant guilty of malice murder. Count two, we the jury find the defendant guilty of felony murder, criminal attempt to commit armed robbery. Count three, we the jury find the defendant guilty of felony murder, aggravated assault with a deadly weapon. Count four, we the jury find the defendant guilty of felony murder, possession of a firearm by a convicted felon. Count five, we the jury find the defendant guilty of criminal attempt to commit armed robbery. Count six, we the jury find the defendant guilty of aggravated assault with a deadly weapon. Count seven, we the jury find the defendant guilty of possession of a firearm during a commission of a felony. And count eight, we the jury find the defendant guilty of possession of a firearm by a convicted felon.
Okay, please publish the other verdict by reading it.
Okay, Demetrice Ross, count one, we the jury find the defendant guilty of malice murder. Count two, we the jury find the defendant guilty of felony murder, criminal attempt to commit armed robbery. Count three, we the jury find the defendant guilty of felony murder, aggravated assault with a deadly weapon. Count five, we the jury find the defendant guilty of criminal attempt to commit armed robbery. Count six, we the jury find the defendant guilty of aggravated assault with a deadly weapon. Count seven, we the jury find the defendant guilty of possession of a firearm during the commission of a felony. Count nine, we the jury find the defendant not guilty.
May I see the verdicts, please? Deputy Ham, please give them to me. Please show this to both parties. I ask the jury clerk to hold the jury.
Ladies and gentlemen of the jury, as I call your number, you will stand and I'm going to ask you three questions, which you will answer either yes or no. After you have any question, you may be seated. Your number 11. Is this your verdict?
Please answer.
Yes.
Was this your verdict in the jury room?
Yes.
Is this now your verdict?
Yes.
Thank you. You may be seated. Your number 12. Is this your verdict?
Yes,
Was this your verdict in the jury room?
yes,
Is this now your verdict?
yes,
Thank you. You may be seated. Your number 18. Is this your verdict?
Yes.
Was this your verdict in the jury room?
Yes.
Is this now your verdict?
Yes.
Thank you. You may be seated. Your number 19. Is this your verdict?
Yes.
Was this your verdict in the jury room?
Yes.
This is now your verdict.
Yes.
Thank you. You may be seated. Juror number 20. Is this your verdict?
Yes.
Was this your verdict in the jury room?
Yes.
This is now your verdict.
Yes.
Thank you. You may be seated. Juror number 21. Is this your verdict?
Yes.
Was this your verdict in the jury room?
Yes.
This is now your verdict.
Yes.
Thank you. You may be seated. Juror number 27. Is this your verdict?
Yes.
Was this your verdict in the jury room?
Yes.
This is now your verdict.
Yes.
Thank you. You may be seated. Juror number 33. Is this your verdict?
Yes.
Was this your verdict in the jury room?
Yes.
This is now your verdict.
Yes.
Thank you. You may be seated. Juror number 36. Is this your verdict?
Yes.
Was this your verdict in the jury room?
Yes.
This is now your verdict.
Yes.
Thank you. You may be seated. Juror number 45. Is this your verdict?
Yes.
Was this your verdict in the jury room?
Yes.
This is now your verdict.
Yes.
Thank you. You may be seated. Juror number 52. Is this your verdict?
Yes.
Was this your verdict in the jury room?
Yes.
This is now your verdict.
Yes.
Thank you. You may be seated. Juror number 54. Is this your verdict?
Yes.
Was this your verdict in the jury room?
Yes.
This is now your verdict.
Yes.
Thank you. You may be seated. Your Honor, the jury has been polled.
Counselor, is there any reason why this jury may not be officially discharged from the performance of their duties?
No, Your Honor.
No, Your Honor.
Ladies and gentlemen of the jury, I hereby officially discharge you from your duties, and the lawyers may want to speak to you. We will now hear from the family. You're hereby officially discharged. We will now hear from the victim's family and friends. Does anybody wish to address the court on behalf of Mr. Arnold? Please come forward. Please speak up. You can come to the podium. Please speak into the microphone, sir. I'm very sorry for your loss. God bless you and your family and friends.
Thank you for your kind words, Your Honor. My name is Ronald Gaynor. Tom Arnold is my wife's brother and the uncle to my two children. And I just wanted to tell the court that we are satisfied and relieved at the verdict rendered by the jury here today. We understand that in the criminal justice system, justice belongs to the people of the state of Georgia instead of to Tom Arnold. And in a way, there really is no justice for Tom Arnold since he still rests in a columbarium next to his parents. So we are grateful for the judgment of the court and the good work of the prosecutors and the Atlanta Police Department people who were involved in this case. Tom Arnold was a very outstanding individual. I mean, some of the things he did, he was a skilled whitewater rafter. He rode bikes. He rode in triathlons on bicycles. He traveled all over the world with his friends. We like to make fun of him. He was a geography expert. And I think the kindest thing about Tom Arnold was that he fostered dogs a lot during his life. And Tom Arnold never met a dog that he couldn't make friends with. And he will be missed in the community, and he will certainly be missed by his family. I think that's about all I can say at the moment. It'll take a while to sink in, and we may have some ups and downs. But again, I'd like to thank everybody in the courtroom.
God bless you.
Thank you, sir.
Does anybody else wish to address the court on behalf of the victim? Does anybody wish to address the court on behalf of the defendants?
Hi, my name's Shakia Tigner. I'm Demetrice Ross's sister. I do want to thank you all for your time and at least for hearing and giving my brother a fair trial. And to you all, I am terribly sorry about your loss. And I just pray God brings you all peace. Where I still stand with support of my brother. I know that it was very tough to make choices based upon what you all hear. But I do know that we serve a living God that is able to transcend all of these moments, and that there'll be more opportunity for people to be able to hear out the full-blown essence of the case. I am still thankful for you all. Continue to trust in God and follow true with your whole heart. God is with you, Christ is with you, and the Holy Spirit is with you. And I just thank you all for the time to be able to stand here in front of him. I stand here just still praising God for you and knowing that in due time and in due season, God will have the victory. So again, I send my condolences to you all. I pray that God brings you peace. I know that we serve a God that is more than able and more than capable to heal. And in due time, I pray that be your portion.
Thank you.
I believe,
My name, my name is Valerie Ross, and I am Demetrice Ross's mother. This has been a long 3 years of pain, not only for the family. I pray daily for y'all. Every day I pray for y'all. And I pray because it's a bad thing that happened. But like my daughter said, my son is a God-fearing man. My son is a humble man who I never, ever heard raise his voice or made a curse word. He is a mentor of my grandson, who is a student, 15 years old. They look up to him. I have never had any problems with my son. And I understand y'all had to do what y'all had to do. But I don't think it was enough time. But like I said, God, God has the last word. And I understand and I trust him wholeheartedly. There will be another time. There will be another time. And I do believe victory will be served. And I pray to God every day, that he continues to give us the strength to get through this. And I believe my whole heart, with 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 my whole heart, my son, Demetrice Ross, is innocent. He's innocent. You did your job. They did their job. My heart, I pray daily for y'all. I pray for Miss Arnold family. I pray for Brandon's family. I pray for my family for healing, because I can't get through it without God. I can't. That's my strength. That's my go-to. That gets me through everything that I'm dealing with right now. And my son is a humble person of love. He's a humble person that wouldn't hurt a fly, never hurt anybody in his life. I just wanted to let y'all know there will be another time. There will be another time, because there will definitely be an appeal. Thank you.
I have a very difficult job. And I have probably tried 200.
there was one more person who wanted to speak.
Who is that?
Mr. Williams' mother.
My name is Sabrina Stokes, and I am the mother of Brandon Williams. That's my youngest son. And I want to thank you all for what you've did today. My condolences to the family. Oftentimes I've wanted to say something to you, but I know I couldn't. I'm always going to support Brandon. I know the truth. I wasn't there, but I know the truth. I know that he's not going to lie to me. He's had a past, but he's learned from that past. I told him often, pick and choose your friends wisely. And all I can do now is support him. I am in agreement with Demetrice's mother. We will move further. We'll do this until we can't do it anymore, because we know that these boys are innocent. And I thank you, Judge, for your time. Thank you, Ms. Morgan. Thank you.
I have a very difficult job. I've been a Superior Court judge for 20 years, and I had probably tried 200 felony jury trials, most of them murder cases. And people say, how do you do it? How do you deal with all that sadness? Because there's never a happy day in this room. And I say, well, I compartmentalize, and I leave it at the office. But this case has really affected me. Two words come to mind: cruel and evil. That's what we have in this case. It's cruel and evil. There's no reason we should be here. And there's two types of people, of criminals, that I believe should belong in prison. Those that society is afraid of and that we need to be protected from. And those that, because of their past conduct, and yes, a lot of the jurors, prospective jurors, got it right. A past criminal record is indicative of a future criminal record, absent some intervening positive change. So the second type of criminal is the person that I know from their past, without some positive reform, are going to continue to commit more crimes. And both of these defendants fit into both categories. Now, this was a cold and calculated murder. These defendants' conduct was devoid of morality, and it was willful and intentional, without any concern whatsoever for the value of human life, all human life. We all should understand the sanctity of each and every human life. And I'll say this to the defendants: your repugnant and depraved conduct has earned you the certainty that each of you will perish. Both defendants are present. I must advise you, you have 30 days from today's date to file what is called a direct appeal to the Supreme Court of Georgia. And you have 4 years from today's date to file what is called a habeas corpus petition for relief. You may take them back. All right, y'all may go through them.